Yes. The impugned judgment and decree dated 31/3/2014 is hereby set aside. Case is remanded back to hear the matter on the issue framed by this court.
Yes, both the appeals and the revisional applications are dismissed as not maintainable.
My lord, may I permit to mention on contempt matter, my lord?
Of this court bench,
Yes.
what?
My lord, violation of the my lord's order passed by your lord's and my lord.
Our orders are violated.
Never.
We'll sit one day.
Yes. No intent.
Then go to the Lawajeva bench. Why here?
Judgment.
Absolutely.
You filed long back. I'll mention there.
Give, we'll dispose of.
Application.
We'll take up the responsibility of the registrar.
Application.
Give all the applications.
Any.
Applications and order 41 only.
Any.
Please don't mention for hearing matter.
My lord, may,
Please do not.
my lord, may I be permitted to, and I am praying leave to file second appeal without certified copy of the appellate court, my lord. My lord,
When the judgment was passed,
2nd December, my lord.
what is the urgency?
My lord, urgency, my lord, they are going to take the possession of my letter.
Have they put the degree in execution?
The degree is not put.
Then where is the difficulty?
Well,
Now
there is-
execution case, then notice, lot of things are to be done. Get the certified copy in the meantime. No. Do it.
That two matters has been fixed today as forwarders,
So
not appeared if appeared tomorrow.
why appear tomorrow?
Not appeared today.
Not appearing today. এই কেন আসেনি? সার্ভার না হলে কিন্তু when there is a order যখন ওটা বলেছে না তো ওটা তো এমনিতে দিয়ে দেবে সার্ভারে কি আছে ওখানে বলার যা আছে তো আমরা সই করে দেবো এখানে Yes. Who is appearing?
I was appealing.
Why? I do not find it is not a CAV or something of that kind. Why?
It was reserved for your.
No, it is not reserved for judgment. We find it. Come and argue before this bench because this is not here.
Your Lordship, I am led by Mr. Joydeep Ganguly. Then
When? Tell her.
Your Lordship, any day as per your.
Tomorrow,
Your Lordship,
do it. Other side is here.
Your Lordship, the other side is not appearing despite service. Your Lordship,
Oh,
and the matter
then you come and argue
tomorrow.
tomorrow. Hey, as for orders tomorrow.
Grateful. Your Lordship.
Yes. What is this?
And for the
Item
petitioner, my
number.
lord,
Item number. 2 is for orders. Yes, part heard.
I humbly pray for a Passover, my lord.
No,
My lord,
part heard.
I am instruct.
To be mentioned is item number 2. Item the card দিয়েছো file. Somen sense have তুমি দিয়েছো তো কি করব? আমি তো ওখানে দেখছি for orders part heard. Yes. Oh, no. Can't be taken out.
I pray for a short Passover, my lord, as instructed by the clerk of the advocate on record, my lord.
You are mentioning for whom?
I'm not in the matter, my lord. The clerk
Mentioning
for the petitioner. On the ground
Hey.
of advocate Raja Mentos.
Has he not told you anything?
I'm not in this matter, my lord. I just
No, the instructing clerk has not told anything.
I don't know the advocate and record.
Is
Also.
one of us, Aman Namko, is not inclined to take up this matter on his personal ground. Let this matter be released from this bench. and be placed before the Honorable Chief Justice for passing an appropriate order. I appeared in the matter, don't you?
But I am for the appellant. But this matter was released by the Honorable Chief Justice Mallet and has been assigned before your lordships.
Let us see.
May I submit only one thing, submit your lordship kind approval.
Yes, 1 minute. We have not seen that. What is this? Just 1 minute. Why it has been assigned?
Lordship Mallet Justice
Justice
Bhattacharya
Niranma
Mallet
Bhatt.
was pleased to release this matter on personal grounds, Mallet.
What is the matter?
As the matter relates to,
Did he appear for any of the parties?
yes, the appellant was known to Mallet Justice Bhattacharya Mallet. Is a practicing advocate, Mallet.
Who?
The appellant before your lordship, Mallet.
Where?
In this our court, Mallet.
My God.
Lordship.
Released.
There's some urgency, Mallet. It's a
I don't take the matters.
Item number 5, Lordship, I am for the appellant. Your Lordship was on the last occasion pleased to Lordship direct me, Lordship, to file a compilation of the documents placed before the learned trial court, Lordship. Lordship, that is, Lordship, yet to be prepared, Lordship. I have asked my client, Lordship, for bringing up the documents, Lordship.
What are you talking then? Why?
He was,
we
Lordship,
passed
on
this
his
order?
for some treatment, Lordship, he was out of station. That's the only prediction.
That was done on 20th of November, and
Yes,
now
yes.
we are on 11th
Long
of
time has
December.
passed, Lordship. I tender my apology,
doing?
Lordship, on behalf of I tender my apology, Lordship.
Not this week. Oh, we said first half application, second half.
That matter, the appeal.
আমাকে বলতে দেন
Oh, sorry. Oh. Is your appeal?
242.
242 and 43, my lord. Those are
Why defective?
243 and 244.
243 and 244. Okay.
Yes. This is application is for stay of all further proceedings before the partition commissioner.
This is against a preliminary degree
Preliminary, Malala, I am telling you, lordship. This is
or against a final degree.
no, not final degree. Final degree has not yet been passed.
So
I am telling you,
to
lordship.
know the order
No,
of
no,
stay
that-
which
this
is
is a-
passed.
My lord, this is a different case, my lord. I said
Different case.
facts is different.
Every case has a
initially-
different fact.
My lord, initially I have data the list of this website. It once came up before this honorable court.
The CO is also to be heard.
My lord, kindly see this.
Same order to appeal and revision.
তুই তো ছটপট করছিস কেন? আমি বলতে পারি না নাকি? ও তো ছটপট করছিস কেন?
Your Lordship, Mr. Rabindranath Mahato is appearing for respondent number 2 and 5. He is not in the court premises due to some personal difficulty. Can it be taken up on next week, Your Lordship?
He will not remain for a whole week.
Yes, Your
This
Lordship.
matter was
Yes, Your Lordship. He informed you himself in the court premises, Lordship.
My lord, final degree proceeding is pending because they are pressing hard for that.
don't take steps there,
This week only, Your Lordship, for adjournment.
but you should not press the press for final degree.
Already commissioner submitted report. His examination is yet to be done.
Have you raised an objection?
My lord, we do not know. We have not been notified at all.
Contesting, they prayed for time.
Oh.
This week, your lordship.
Who is the plaintiff there?
I am for the
What
You are for the plaintiff.
plaintiff.
They are the contesting defendants,
No,
I am the
they are
contestant.
not the co-plaintiffs.
co-plaintiffs,
Yes.
and they are represented by two sets of lawyers.
Yes. Number
Very
one
interesting.
died. Plaintiff number one died. I am repeating the son of the. This is
You have been substituted.
yes.
So
They're killing time. Who?
why he's ready with the matter, and then why you are asking for a time? Who is the advocate and record?
Mr. Tariq Mina is
Where is he?
lordship. I'm not aware of the advocate. on this.
Why is not appearing?
Lordship, kindly take it up next week, your lordship.
No, why this matter?
Then your lordship,
And-
this Friday even, your lordship.
No,
My lord, may I submit this? My lord, kindly grant an ad interim stay and fix the matter, my lord, after the vacation assignment.
Appeal is not maintainable stay.
Any day, my lord, after the vacation.
size of a hat is smaller to fit it.
This will not take much time.
21st January 2024 is the next date in the trial court, my lord. Mr. Mahato is leading me, my lord, in this matter, my lord.
So 24th January.
January 21st, 2024 is the next date, my lord, in the trial court, my lord.
So 21st January, the matter is fixed.
Yes,
So there is no apprehension.
that is as a last chance.
Maybe. Then a special chance, then a super special chance. You know what is done in the trial court after a last chance.
22 years gone. Suit of 2002. Party election. On a summons taken after 4 years. On the same
I
time.
have no share, my lord, according to my client's
Time
contention.
in that way.
The father from which the property has been derived to the son by a deed of settlement in 1991. And they have no share at all. They are the daughters. And suit has been decreed, declaring, my lord, 1/6 share of the preliminary. Without considering those documents. Those documents are very much in the record.
Original document didn't file during this.
Although original volume was called for at their instance, marked exhibit.
For comparing the signature. Certificate copy of not-
Oh, what? This is marked
Ah.
exhibit.
Yes, fabricated document.
Wait, what? What proposition of law?
Other-
What proposition of law that the certified copy cannot be accepted
No.
unless
Accepted.
the
Accepted.
comparison?
In the plaint, paragraph 7 of the plaint, we have alleged that it's a fabricated document.
Did you sought for a declaration? Did you seek for a declaration that it is a fabricated document
But
in the suit? You
There is no
ought to have-
defense. There is no pleading also with regard to that.
yes,
You ought to have-
that
ought to have taken, ought to have taken a relief in this regard. In a partition suit, declaration, partition, and then separation is very common. Why you will not? Simple saying one line that it is a fabricated document will not do. How you have proved that it is a fabricated document?
In the written statement, they have not said anything.
What?
We have alleged in paragraph 7. Can you see the print, copy of the print?
Sir, even if it is a suit is an ex parte, does it mean that since no defense has come, so court will decree the suit? Or you have to prove at least?
They preferred appeal here.
Sorry?
They didn't pursue the suit.
Degree was passed against me. That's why I had to prefer appeal.
Yes, and they didn't pursue the appeal. Appeal dismissed by this honorable court.
What appeal? The appeal is before us.
My lord, I am telling you.
Previous appeal.
Let me.
Challenging the preliminary degree.
He will only shout, my lord. Let me tell
And
your
honorable-
lordship, my lord, the facts in brief. What the suit was filed. Filed in, my lord, kindly see, Judge 7. Kindly see the list of dates which have been supplied to you. The suit was filed in 2002.
Yes.
Mr. Mukherjee is leading you.
My lord,
Mr. Mukherjee is leading you.
no. No. See,
Look at the monitor.
Okay,
Yes, my lord, but see, I'm with Maiti, Mrs. Maiti.
Yes.
My lord, the suit was,
Anyhow, Mr. Ghosh, when they showed their inability, Mr. Mahato is not coming, and the execution case or the next date is fixed in the month of January. That's the 3rd week of January. So we can take up this matter in the next week.
next week.
Yes, we can take it up on,
Very well.
or if you want a Friday, we can do it on a Friday.
No, not Friday.
Then do it on Monday, next Monday. Do it on the prayer of the respondent number 2 and 3. Let this matter be listed on next Monday. Date.
Now kindly see, my lord, it does not go down.
Yes.
Which one?
It does not go down in the list. That will cause trouble for me.
It will be taken up.
At 2 p.m.
Not for you, for your junior.
Well, can I take it up at 2 p.m. on Monday?
You are here every day.
Right. She was a bit ill, my lord, for some time. And recently has got eye surgery. Cataract.
That is a age-related problem.
না আমাদের একটা অর্ডার হয়নি মেনশন করব ও আচ্ছা ও আমাদের তো next Monday.
Well, with your lordship's kind permission.
2 p.m. Take it up 2 p.m. Monday 2 p.m.
What is a charm in a 2 p.m. or a 1 p.m.? It will be taken up, don't worry. Monday, because we have segregated 1/2 for application, 1/2 for the
Application.
order 41. So we have already done that. So it will be taken up.
In top of the list. Application top.
Or it is already there. Don't worry about it. It will be taken.
There are so many applications.
Those will not be alive. Don't worry by Monday.
I'm the
Well, with your kind permission, my lord, one second appeal has to file, my lord. Second appeal has to file, my lord.
Mentioning time is over. We have already disposed of one. No. Come tomorrow. We'll see.
In this, I am for the appellate.
What is that? When the judgment is passed by the appellate court? Just one.
My lord, 8th September. 8th September. My lord, today is the.
Then what you were doing for so long?
My lord, actually, thereafter, my lord, Puja vacation was started. my
No,
lord.
Puja vacation is started from 19th of October, sir.
My lord,
You had more than 1
it's
month.
tomorrow. My lord. Yes, today, my lord.
What?
This time, my lord.
Time is you have applied for certificate copy.
Well, on the trial court certificate copy is not there, my lord. They have, they said, department said to take leave of, my lord. There is a.
Why leave? They will say that it is defective.
My lord, they will
Have you
say
annexed
that-
the photocopy?
No, there is a photocopy, but they are saying you take leave. Otherwise, actually, we shall not take it.
Sorry?
No, the matter will be.
Hey, why they will not take it? The stamp reporter will give a
This is the
note
thing.
for that.
That will be defective, but they will not. They are not taking.
No, Nevada.
Huh?
Go. Tell him. You can't.
You
You have to accept it. তারপরে SR যা আছে সেখানে রিপোর্ট দেবে ডিফেক্টিভ নেবে না কেন লিভ দেওয়ার দরকার নেই এমনিতে দেবে
For the appellants, my lord. The appellant, my lord, filed partition suit before the.
What is the defect, sir? It is defective. Where is 10 rupees?
My lord. By
Why you people file the appeal with a deficit court fee of rupees only 10?
sorry, my lord.
From where you got all these notions?
By today, my lord, I shall
80 rupees is a court fee. You have put in only 70 rupees. You don't know. And you say when this is filed? This is filed on the date is not given. The presentation form is blank. August, at least August 2023.
my lord, by today, my lord, I shall cure.
Now the limitation has intervened. What to do?
By today, my lord, I shall cure.
By today. The time to put in the deficit court fee is extended by 2 days from date, comma, in default of putting the court fees within the time indicated herein above, the appeal shall stand dismissed. 10 rupees you can't give.
My lord, sorry, my lord.
I'm for that.
Again defective. What is the defect? Report on this for in time or in form cannot be done as certificate copy of the FMA, FAT, include order what? FAT must be against the donation of degrees also there. Yes, it's a probate application. In time, why he cannot file? Certificate copy is a Where is the first page of the certified copy? Obviously, that's how the limitation. This is of 18 only. The appeal is filed in 2023. Where is a complete copy of the certified copy?
As the client has
No, this is not correct. There must be some noting when you filed an application for certified copy, when the requisites were notified, when you put in the requisites, when the certified copy is made ready. The stamp reporter has shown his inability to give any report on this. Nothing is there. Only on the back reverse of each page we find a seal of a trial court that shows that it is certified copy. But also on the top of it, the application number is also written. which I do not find here. Always at the top, there is a handwritten, there is the application number.
My lord, as
What
it
is
was
going on?
delivered to the client, he has handed over.
Sir,
I know that.
this is the order of 2019, which you are assailing now in 2023.
23.
So at least the period of limitation he has to count. You may have filed an application for condonation, but he has to say. There is nothing I find even on the reverse page. If I can find those, I can do that. We can very well say so. Nothing of that kind. I do not know. I never come across with this. There must be a one paper more front page, which contained all these details.
So on the first look, I have raised that particular question to the client, but he stated me that he has been handed over this particular order.
It can't be.
Because
Can't
in
be.
High Court
Sometimes,
also, there
sometimes
is a
on the
stamp,
reverse of the last page,
Your Lordship.
they put
Date
it.
of
But this is
application and date
also silent. No, sir, I can't believe it.
My lord, bona fidely, I am submitting that it has been handed over on 19th of September 2023. That is delay.
That is, I understand, sir, but for the purpose of limitation, one has to understand. Hey. Indian Succession Act of say that or a district delegate. Such and such. So district delegate is there. The district delegate.
It is there.
Attention. Proceedings shall have the form.
My lord, I tender my apology, but the law clerk has, I think, inadvertently mistaken this. This is the original certified copy and date is there, Your Lordship.
I showed you.
As I am going through the file, I have.
Sir,
found-
this is I wanted.
Yes,
This
yes.
one I wanted.
But mistakenly,
Okay.
my law clerk has
This is
done
what
this,
is
Your
here.
Lordship.
My mistake. This is really we wanted.
Yes, Your Lordship.
And you say this is all handover. I inquired.
As the
What inquiry you did
as
after
the,
looking at it?
actually, my law clerk has.
Then why you said that I inquired?
The client has been brought forwarded by the law.
Sorry. He can only draft when there is no contest. Yes. Yeah. You look at section 272 also empowers the district delegate. State account. State judicial officer to act for district judge as delegates to grant the administration in non-contentious cases within such local cases. Seasons. District delegate. It will be filed before the district delegate state finds contention. It is only when then it says that the moment the contention that he kept, then he kept. That's all. This is the contentious application. Now, the question is, if district delegate has asked district who was not there before the district can file a claim or he has vocation. Because the appeal says 291. It's district judge. You know, so it says district. Now, what is the remedy? It's letting them go further. Revocation. Probably see. Okay. Chapter 360. Errors in the position of setting for the judge. 6 of the decision of judge. Decide the amount of the ground that they will dispute. After the week of what just cause expression just cause and seem to exist here. If you speak to obtain a ground, also issues conceiving from courts. True. Such a like become Talk about the simply says a grant of ground. These are the grounds on which you can, it says the grant delegate or the support. It is in relation to grant. And appeal is a relation to judge, so to the district judge. But tell us whether appeal lies.
Your Lordship, at the time of granting of probate, my client was the legal heir, but his name was not included.
Then why not under the revocation 263?
Lordship,
Then why not under revocation 263? This is one of the ground that he has suppressed, concealed that you are the heirs.
but I came to know the fact
Citation.
in the year 2023, and I came to know the fact in the year
No, that you are not understanding what is troubling us, because the appeal against the grant of probate or let us say administration lies under section 299, and that talks about the district court, the district judge. And district judge is the only authority or has a power to decide a contentious cause. If a district judge has decided after ruling out the objection, then definitely appeal would lie. But here, district delegate does not have a power to decide any contention. If he has, then whether the appeal lies, because you were not there, you did not oppose when the probate was granted. So if there is any concealment, can an appeal lie? I'm asking this very simple question against the order granting probate by a district delegate. That's the simple question I'm asking.
but, my lord, kindly keep it on Monday. I'll come back with the answer. Your Lordship.
What to do? We have taken a certificate of the record. Record. It's not a sheet on the applications and all, everything he has taken. Original is not there. It's good to come. This is an application. Serial number. Applications. Separate. this is, I think, not wrong because no, it is authentic number. No? Every phase they have actually from every document they have put. This was an application, one application, so they have put it. This is the another application which just says certified to get copy. So every application they have done. Take out something from here and then look at it because this is the one document. So we have taken out from here. But pagination is not here now, so we can't say so. Have taken out the stamp. At the end, it's not there. Because these are the officials. 18. 5, 6, 7, 8, 16. It's taken out 12, no, 12, and then 13. He has taken out from here. Then what about 14 and 15? Oh, order number 15 is here. Then, 14, 15 is here. This is here. Then this is 16. So, sir, the blunder has been done. Is a big blunder which you have done. You have taken out certain pages from the middle of the certified copy and annexed it. Can you do that? You have consciously taken out 3 or 4 papers from the middle of the certified copy and then you have annexed it. We could correlate from here. We will dismiss it. This is not absolutely expected.
I tender my apology, Your Lordship. Kindly dismiss me.
What is this? No responsibility. When you sign on the papers, don't you realize that you are the advocate and record? You sign on the memo filed through me. Will you not realize? Have you realized what has been done?
Yes, Your Lordship.
This is a complete set of certified copy. Certain orders which are relevant. Those pages has been taken out from the certified copy and included here.
The entire
This is apparent because we could see. Certified copy of the entire record has been taken by you.
Lordship,
So you ought to have annexed in its entirety. There was no difficulty.
for the first time, I am filing an appeal case, Your Lordship, and that must be a mistake done by me.
You have not filed any appeal before.
No, Your Lordship.
How long you are practicing?
I'm practicing since 2011, but only I was doing read cases and other. This is the first time I'm preparing an appeal. Your Lordship.
But again, the point is whether appeal lies.
Kindly give me some time till Monday, Your Lordship.
Seen the report of the stamp reporter. this stamp report has showed its inability to put any report whether the appeal is in time and also inform as the certified copy of the impugned order as furnished does not contain the requisite informations required for the purpose of such report. At the time of hearing the instant application, the learned advocate and record of the appellant hands over the complete set of a certified copy obtained from the court below, which contains all the necessary and or requisite informations and or disclosures for the purpose of putting a report by this stamp reporter. Astonishingly, we find that certain pages from the certified copy has been taken out and included with the memorandum of appeal filed before this court. It is unacceptable that the advocate and record would act in such a lackadaisical manner, and the complete apathy to the duties and responsibilities is apparent and evident therefrom. Since the litigants should not suffer because of the lapses and laches of the advocate and record, more particularly when the certified copy is obtained by the appellant, we feel that the justice should be served if the appellant is directed to include the entire set of certified copy produced before it, after rearranging the papers, segregated therefrom, and included in the memorandum of appeal. Here and now. Do you have the extra copy?
No, I will ask my clerk to copy.
Do it. Full set. And come ready whether appeal lies. Mr. Ghoshal, what do you think in this matter? Can a person challenge the grant of probate by a district delegate on the ground, whatever, which is included in a provision relating to revocation? Because the 299 says the appeal against the district judge. Whether the district delegate, I have doubts. Whether I have doubts.
Some district judge, then it cannot be done in the court below.
They cannot be done by a district delegate.
Yes. Come here. That's how I had to face one such matter. I raised that point. Frankly, is there, if it is order of district delegate, subordinate in hierarchy, in some cases, appeal lies with district delegate.
Appeal lies. First question is whether really appeal lies against the district delegate, because the provisions are that if the district delegate finds that the probate cannot be granted, then he has no authority to refuse or reject. Then he has to send the matter to a district judge. But if he grants, means there is no contest, because it has not converted into a contentious cause. Then in that event, anybody who feels that grant should not be done can file an appeal. I have doubts. Or his right emanates under 263 by virtue of revocation.
It is a situation.
Peculiar.
It's something novel. Not that it has been hard on the in either ways. It is a question of jurisdiction of the court itself.
Work on it. Do some research work on it.
be very frank, more research work was done by me, but I have read it, these provisions of some one or two matters.
Do some research work for the court.
I shall try my mind. I shall try.
Yes, call the next matter.
I'm for the
Yes, madam.
appellant. I'm for the appellant lordship. This appeal is the suit is for declaration lordship. The plaintiff is the daughter of the plaintiff is the daughter. They are the cousin, brother, and sister lordship. The father of the plaintiff gifted the property to the
Brother,
to his nephew lordship.
nephew,
Nephew is the
and
appellant.
you are a niece.
I am the nephew. I am the appellant.
Oh, you are a nephew.
Yes, lordship.
So,
And the daughter filed the case, lordship.
daughter means daughter of the donor.
Owner. Daughter
So
of the original owner.
the donor did not give it to the daughter,
Yes, lordship.
gave it to nephew.
Yes, lordship. And they challenged the deed after it was executed in the year 2000.
She challenged the deed.
Yes, lordship.
So you are not a plaintiff, you are a defendant.
I'm the defendant.
Okay. And the suit is decreed.
Yes, lordship.
So declaring that deed of gift to be void.
Yes, lordship.
Fraud, undue influence,
Lordship,
coercion.
Lordship, they said that the donor had no mental capacity to,
Okay.
but no documents, no evidence.
So what injunction? This is the first appeal we will hear out after what application you have taken out. Injunction not to what is
status quo. Status quo to
what is status quo?
not to execute the order, lordship, and the status quo may be maintained.
But is it an executable decree? What are you talking about? Is a decree for declaration is an executable decree? Oh, you are also permanently restrained from the interfering with her possession.
Yes, lordship. I am staying there, lordship. Now they are disturbing my possession, lordship.
That will not do.
That is, I'm there for.
That will not do. This part of the decree is executable. We under order 21 rule 32. But declaration ever not heard of. Serve the copy, madam, we can't. Because once the court, after the entire evidence has been taken into account, held that the plaintiff is in possession,
No,
you
lordship,
cannot seek for injunction
lordship,
that not to disturb your possession there.
Lordship, I am in possession, lordship. They are not in possession.
But the court has held, madam, have you seen defendants? You are a defendant. Defendants are hereby permanently restrained from interfering with the plaintiff's peaceful possession upon the suit property. What does it mean? You may say you are in possession, but the court has held that plaintiff is in possession.
Plain, lordship, it is clear. She was not in possession, lordship. She got married in the year 1960. In the year 1960. She was not with her father for a long time, lordship. I was there from, and that is their case, lordship. I was there, I influenced the father. It is from the plain, lordship, it is clear I am in the position.
Oh.
Lordship, they said they were not in possession. She was in her in-laws' house, and I am there for since my birth. I am in that house, and still I am in.
Was there any issue relating to possession?
Lordship, they are now disturbing that agricultural property.
So why the court has come to a finding that shows that the finding is wrong?
Lordship, that is that from the plaint, Lordship, I'm
Show us the plaint. Show us the plaint.
Lordship, Annexure page 16 of the application, Lordship, that if I can come to the typed copy, Lordship. From paragraph 7, Lordship.
No,
That after the
no. Sorry, I am reading from a judgment, but the judgment, while recapitulating the plaint's case, has said something else. Where is the plaint? Let us see if it is a wrong finding.
Page 16 it is that.
Of the application.
Yes, Lordship.
Yes, show us. Paragraph.
Paragraph 7, Lordship, that after marriage, the plaintiff started to reside with her husband at the Gopal Mall.
No, you have not. Then you have to read. But she has made out a case that after the marriage, I started living in my matrimonial house. But
Yes.
since my father was there, he was ailing, then I requested this brother, the defendant, to take care of the father. It
Yes.
does not mean that the position was given. He may go and take care of the father only.
Lordship,
And then she said that after the death of the father, when she went to cultivate the land, then there was a resistance from your side.
Lordship, her father passed away in the year 2009.
I do not.
And he said in the year 2015, she has been registered.
Maybe the reason is
There was
that
no ground for leave. That why he has.
she does not. That does not mean that I have lost my position from there.
Lordship, I was in possession. Lordship. Suddenly, she said in the year 2015 when I went
But
to.
you can't say that this. Then the court must have, on the basis of the evidence, on the basis of the statement, have decided ultimately.
Lordship,
We can't at this stage. We can't. Sorry, we can't pass you an order of injunction now. Serve the copy. It's a first appeal. It has to be heard. And application is returnable 1 week after the reopening of this court. We can't go beyond that. Sorry.
Because I appear for the appellant, Mr. Mukherjee is leading me.
My lord, I am for the respondent number 1. I am led by Mr. Mitra. My lord.
Yes, yes, Mr. Mukherjee.
My lord, your lordship will kindly recall that Mr. Prasad, Justice Prasad was not there, accepting my prayer for an attempt to be made for settlement between the two brothers. Your lordship desired a meeting to be held in the chamber of Mr. Mitra with the representatives of all clients, and also desired that I should participate virtually. We had the meeting. On all points we have agreed. On 3 points are yet to sort it out. The representative of the other side is not in the town. Lord, I am praying, Lord, kindly take it up on 21st.
Yes, my lord, 21st, my lord.
So mostly major problems have been sorted out.
Yes, out of 17 properties, my lord, we are ad idem on 13. Now, my lord, the issue has narrowed down to 4. Now, my lord, I'm sure, my lord, we can work it out, the remaining 4. If lordship keeps it on 21st, 20th or 21st, as Mr. Mukherjee has indicated, my lord, we are agreeable. We can come back to your lordship and, my lord, we can.
Kindly make it 21st, my lord.
So in the meantime, both of you will.
No, we had a talk.
Yes.
The representative of the respondent had to answer, had to deal with it. He's out of station, that's why you are waiting.
for him to come back and have it settled again.
Okay. Yes. It is submitted by the councils appearing for the respective parties that in terms of the order dated 3rd to 23, substantial progress has been made and the parties are ad idem on certain issues, barring few, which requires a further deliberation, which could not be done because of unavailability of the representative of the respondent. In view, both the councils suggest that may be fixed on 21st December 2023. So in view of the above, let this matter be listed on 21st.
Grateful, Lordship.
Mr. Mitro, sorry, Mr. Mukherjee, sorry, I could not accede to your argument in other matter.
It's all matter of your Lordship's decision.
Yes?
Your Lordship has decided. I have not yet gone to the judgment.
Thank you.
I was making an attempt, my Lord, out of nothing, literally.
No, that was a very unique one because we did not experience this kind of an argument. At least I have not come across to that. It was a really, I would say, the brain churning that explodes the brain, no doubt about it.
Grateful, Lordship, my Lord. I made my best attempt. Nothing more to be done.
Yes. Thank you, Mr.
Grateful, Lordship.
Mr. Mukherjee, now one issue. We were talking to Mr. Ghoshal. When you are there, then we had a privilege of asking you this also. Because there is one matter where an appeal is filed against the judgment, against the order granting probate by a district delegate. Appeal against a district delegate or granting probate. I have issued doubts that under section 299, whether the order granting probate by a district delegate is applicable because he has only authority or jurisdiction to decide a matter which is uncontentious. If he feels that it is contentious, then he has to refer the matter to district judge. Even if he feels that he is not able to grant the probate, even if it is uncontentious, then also he has to refer the matter to a district judge. And 299 talks about the appeal against the district judges.
Yes, right. My Lord, I can't tell you, Lord. My Lord, I have to go to it and tell you.
Please ponder upon this issue and then if you get something.
Grateful, Lordship.
Thank you. Yes.
Well, I have checked up the file, my lord. There is delay of 217 days. Lord, I am to file application for condonation of delay.
It appears that the instant appeal is filed beyond the statutory period of limitation provided therefore without accompanying the application for condonation of the delay. Full stop. On the prayer of the learned advocate appearing for the appellant, let this matter go out of list to enable the appellant to take appropriate steps.
But should I serve beforehand the respondents?
First file it.
Published.
Review of whose order?
Well, it's a review application, my lord.
Whose order, sir?
The Lordship's order dated 7th of January 2020.
Sitting with Justice Savanto.
2020. By your lordship.
But the stamp reporter has indicated you have not filed Wakalatnama.
I believe, my lord, it had later been filed in the department.
Give us the filing number
আমারটা আছে?
so that we can direct the department to stand with the file.
Yes, my lord.
Show us that filing number.
That was the trouble on a long pending about the filing of Vakaratnama.
Sir, there must be a noting in the file that we learned from you. Whatever you file in the department, there must be a noting of the filing number. Please. At least the advocate record must have.
Well, would it be your lordship's pleasure, my lord, if I file the Vakaratnama in court? Say a fresh Vakaratnama.
I don't mind.
It's on the next date.
What is the matter
Expect a
about?
file for it?
Yes.
You?
Fresh, because of notarial absolute change.
My lord, a fresh Vakaratnama,
Where is
your
the
lordship.
application?
Lordship kindly gives me liberty to file
Mr. Ali, there are another difficulty. because
contempt application.
Only the memorandum which is filed.
No, that has been
Application.
that has been read. The memorandum of appeal, my lord, was filed.
But not memorandum of appeal, a memorandum of review.
Yes. The application of
not the
review to
application.
yes, sir.
There is an application for review.
With the,
Only stay.
one of the review application was filed. I believe.
Where is the review application? See,
It is
but it can one which is stay.
no, it is a stay of operation.
36.
ওটা কি আছে?
36. I think.
না, না, view
Next level original, sir. 36. Review.
Quota 27.
This is also a memorandum too.
Memorandum has been filed. Memorandum of review has been filed. It is so.
It's not an application.
Memorandum review number 36.
Oh, yes, yes, I got it.
It has been filed.
A very bad man. Containing only the grounds, no statement, nothing of that kind. Is this a way?
So, at the fag end of the year, a review application coupled with a contempt application is too hard.
Hard or hard?
Too hard.
Hard.
Yes. So,
File a contempt application. That is item not 255.
What?
Item 255. I have also filed a contempt petition.
What is the order which was passed by us?
Well, the order was passed
I think
on,
it is me who has committed an error.
this is on 7th of January 2022.
That we got it.
Yes.
What I have committed a
Well, the basic sum and rule of the entire contention from our side is, well, there was the rule, not rule, my lord, it is the memorandum by which the appointment and the discipline of the teacher has to be conducted. But there were a number of, my lord, division changes in the structural change of the management of this type of school was done. So that has to be gone into. But for that, my lord, I have these copies of the books that your lordship has to be. Next record. Will you? Next day. No.
Mr. Ali, the difficulty is because the application for review is in such a, may I use that word, a shabby manner, that it does not contain all those you intend to rely. There is no averment in this regard that what is an error which is to be seen into it.
But the service of my lord, my Lance's client was terminated because of gross indiscipline. Now, whether it amounts to indiscipline, his actions, is indiscipline or not, my lord, that has not been gone in. So, in my respectful submission, my lord, in order to address to that question as to whether the action of the teacher amounts to discipline or not has to be gone into through this circular. At the time of the appeal, my lord, unfortunately, this was not brought to your lordship's notice. So that will be my contention, my lord.
Who was appearing? You are for the state.
I'm for the Jilla Parishad.
You were represented there?
Yes, nodal officer.
No, you were represented in the anniversary? Yes. Who appeared?
The district nodal officer.
Who?
She is dead. She's
dead now.
She expired.
Who appeared?
Manjuli Chaudhary.
But her name does not appear in the cost title, the appearance.
In the order, I don't know.
In the order impugned, it is not there.
Oh, for this day, Murshumi Mitro
Yes, and for
and Sarwar
Jahan.
Jahan for the respondent. For the state
They
is
appeared.
totally Bhattacharya.
At that time, name could not came by mistake.
I could not get it. They could not.
He appeared করেছিল তার জন্য এই রেসপন্ডেন্ট কত নম্বর রেসপন্ডেন্ট
2 and 4.
not recorded by in the order এই দেখ
দেখেছি
দেখেছিস তো তাহলে from the order, my lord.
And second thing is there are many defects, Mr.
Under review, for the order under review, I find Mr. Sarwar Jahan
Yes,
with Mrs. Mausumi Mitro.
correct. Whether they represented your
I
client,
believe last time she also appeared. He did. Sarwar Jahan did.
I am asking for another reason. which I will disclose. That's why I just wanted to have the clarity on this. You said that who was representing the Jila Parishad?
I don't know. He appeared to receive.
Time Mrs. Manjula Chaudhary appeared for Jila Parishad. Mrs. Manjula Chaudhary
Yes.
appeared for the Jila Parishad.
She is no longer.
She was appearing also before your lordship, I know. No, she is no longer there.
But there are two hurdles. First thing is there is a deficit court fee of 200.
Yes.
Unless the deficit court fee is put in, the appeal is not competent. I think review application is not competent.
Correct.
The second one is there is a delay of 372 days. So condonation also has to be done. There is no application for condonation.
The review application? Huh?
Last occasion order kind last.
My lord, my learned colleague says whether your lordship had given us the liberty that there is no necessity of giving the condonation application.
Why?
I don't know, my lord. There might be an order. I don't know.
And the last order, my lord.
No. There is no order. Only there is one sheet, order sheet, which simply says department says out of time. Please look at this.
জানি না এসব কি হচ্ছে কি
Now,
কি হচ্ছে কি
please look at this. এটাই দিয়ে দাও। আরে ওইভাবে দাও যেভাবে দিয়েছি। এটাই পড়াতে দাও।
এইগুলো যখন রেখেছেন এইখানে একটা কেটে দিলেই হয়।
We'll do that. Look at the report.
Yes, 372 days. এই কোর্টের অর্ডার গুলো কোথায়?
There is no order, only one sheet, order sheet. These are all mentioning slips. A formal application is required.
Well, there is an order on 24th of March 2023. It is submitted that the memorandum of review has been filed subsequently in the department. 13th February. Yes. But that note of the office note was on 13 February 2022. Delay of 372 days. Now on 24th March 2023, your lordship's order is memorandum of review has been filed subsequently in the department. Let the same be tagged with the instant.
That's only, but the limitation will not go because you said that you have filed the memorandum of review. So we say that let it be tagged because previously it was only an application for review was filed. And under order 47 of the codicil procedure, it should be in the form of a memorandum.
Mutant is the memorandum.
So that is what we say that when you say you have filed a memorandum, that we say tag it. But we did not dispense with in that sense. Limitation has to be there.
Yes.
Second copy. Yes. There's a course record. No, these are all mentioning slips. These are all mentioning slips. So we'll have to file a formal application.
A formal
And put in
application
the
has to be,
deficit
yes.
court fee. Put in the deficit court fee. 200 rupees.
Well, it is inept handling of the entire matter, my lord. Why I take onto my head, my lord. I have to.
Well, this particular review application should not stand on the way of my contempt application.
It will.
2022, the order was passed. Immediately you join, allow direct lordship directed. He has not allowed us to join. A defective review petition has been filed on that basis, my lord. They are enjoying the non-compliance of the order of court. From 2022 January till today, not been, my lord, allowed to join. I am nearing 60, but within 2-3 months I will be 60. Then they will say you are retired. What should happen to me? Lordship's mandatory order competent authority directed to engage the petitioner as Shikha Samprocharok in MSK, where he was engaged by the creating a supernumerary post in the post MSK within 4 weeks from date. And that was an order of your lordship passed as far back as on January 7, 2022. Till today, no compliance. The man is, my lord, running from pillar to post and loitering in the corridor of court. Court's order not complied. I have filed a defective review out of time, all sides of defect. This should not be, my lord, as a shield to them, my lord, to non-comply the order of your lordships.
Yes.
You should consider this, my lord. Consider this, my lord.
In the report of the stamp reporter, indicating various. Stop. It appears that there is a deficit court fee of rupees 200.
So pending review application, he should be sent back. Sent to jail.
As well as
Right.
effective though. The review proceeding is filed beyond the statutory period of limitation provided there. So we extend the time for putting the deficit court fee by 2 days from date.
Order a
Court
copy.
indicates the review application shall stand dismissed.
No.
Let this matter be listed on Friday. In the meantime, the minister shall take an appropriate steps with regard to the delay in filing the same.
Kindly pardon my
2 days, put in 200 rupees, take out an application. We are fixing it on Friday. In the meantime, application should also come.
My contempt application be also, my lord, come on the same day.
If 200 is not put in within 2 days, review application shall stand dismissed.
Lord, this is government.
200 rupees.
Yes.
200 rupees.
My lordship will kindly pardon me. My lord, it is my. I shall come up with it.
My contempt application may also appear on that day.
Yes, see, it is an independent proceeding.
No proceeding is there. It is absolutely zero proceeding today. Lordship is giving life to a dead body.
Your contempt application is an independent proceeding.
But that lordship is not taking up, my lord, because of the fact that review is there.
That's why we fix the matter on Friday.
My matter will be also fixed on Friday.
Let it be called. It is appearing in the list.
Yeah, item 255.
Let it be called. Within a very short period of time, it will be called, and he is there. Don't worry.
As well.
Yes,
My learned friend said your lordship is giving life to a dead body. He doesn't know that life to a dead body can be given by planchette.
Huh?
It will not have.
Yes.
My lord, I am the applicant in the instant review petition.
Change of affidavits.
My lord, affidavit in reply has already been served upon the other side. My lord, here is the copy.
This is the matter, my lord, which we mentioned before your lordships and my lords had told us, my lord, at the time of mentioning, my lord, not to underestimate the pace of your lordships. We mentioned it with a 3 days.
My lord, the
So you rightly underestimated the pace. So now tell us.
my lord, Mr. Kulnan manages appearing as a senior brief in this particular case. My lord, he is not available. I've been instructed to sort for an accommodation. My lord, there was a direction to submit an opposition. I have complied to that effect, my lord. But so far as the submission is to be made, my lord, I am completely in dark. I have no such instruction.
A detailed judgment was delivered by your lordship, my lord Justice Tandon, sitting with my lord Justice Rabindranath Samanta as his lordship then was. My lord, after that, my lord, because of this review application, my lord, we are deprived of the benefit of, my lord, the detailed, my lord, judgment, my lord, passed by your lordships. And, my lord, only because of pendency of this review.
Where is he?
My lord, Mr. Banerjee's Mrs. Parliament is going on, my lord. He has to move there, my lord. He all have been instructed to sort for an accommodation. He will leave. He shall appear on the next day.
What is the next date?
My lord, I will be very candid. The instruction that has come from him. My lord, any day after vacation, any day, my lord. That have been told, my lord. I'm just being an emissary.
So he's insisting.
Moreover, there is
filed a
if
contempt.
We did not, my lord, because of this review application.
Then what to do? Then what to do?
my lord, moreover, state is supposed to submit an APTP as well. So far as the state is, I suppose, whether there is any existence of a particular post or not, that was to be taken into consideration.
Wants to, my lord, argue this on
My lord, that is what I've been instructed. So that is being the reason, perhaps. I'm not getting into the argument.
We did not, because of this review application, did not want to unnecessarily trouble your lordships, because this review application is hinging on a sole.
Now it has come. What you have to do?
Kindly, fix a date this side of the vacation. The clients have started castigating us.
You talk to him.
But I can only make a request to him. Both of us
No,
leave it to
you
your
talk to
lordship,
him.
I can only just make a request to him. But I have my senior.
Time needs to-
Adjournment is sought.
Any date subject to lordship's kind convenience, my lord.
No, our convenience is every day. Even today is a convenient.
The reopening week itself, my lord. Reopening week, my lord. Reopening week.
Because the council, he says that he is busy there.
I understand, my lord. But we'll come back immediately after reopening, subject to your lordships.
I'll leave it to your lordship.
When-
I will
when
get in
the-
touch with
when
him
the
and I shall
winter
inform.
session will end.
I shall get in touch with
When the winter session will end.
My lord, prior to Christmas, I think. Subject to correction, my lord. Prior to Christmas, I think. Subject to. He may not be doing obviously.
all what have been instructed by by Mr.
Let
Banerjee.
Let the affidavit in opposition filed by the writ petitioner's respondent and the reply by the review applicant be taken on record. It is submitted by the counsel for the appellant that the senior who is engaged in the matter is indisposed and prayed for an accommodation. In view of the above, let this matter be listed on. Can we do it on 4th?
Yes, my lord. So far as I am
4th
concerned.
is a Thursday.
Thursday, man.
I'll leave it to your lordship.
4th.
Grateful.
Extremely grateful.
Actually, I'm for
Section 5.
let's see section 5. Let's see. First review application filed before this court. Second round, lordship. First review application.
No. Please let me understand. This review application is against the order disposing of the review.
No, lordship. Main appeal.
Now he has filed a review application, moved before the lordship when my contempt application heard by your lordship. Now kindly
No, lordship. First application.
Let me first understand, sir. You are
First review application filed before this lordship.
first.
First time earlier occasion I already filed a review application. This application is withdrawn on the basis ground that lordship defective lordship. Lordship is liberty lordship given to me for filing review application lordship. Thereafter I file a review.
Oh, this is really virtually a review application in terms of the liberty granted to you.
Lordship.
Earlier review application was allowed to be withdrawn on technicalities.
Lordship.
No difficulty.
I annex this order lordship.
Yes.
How much days delay?
Lordship. 84 days lordship.
84.
My lord, I am no objection. Because of that, there is no, it appears from the memorandum review, my lord, there is no ground at all.
Ground.
Because of that, my lord, who has filed the review application? My lord, this is the order which has been passed.
Who has filed?
My lord, this is the BDO. I have challenged that order, BDO. And
Whether the BDO was a party to the proceedings.
Yes.
Was he a party?
Yes.
Then he can.
My lord, this
I filed a review application on the.
Not.
I filed it.
There is no ground at all.
That is a different merit. You were saying that who has filed. So I was surprised whether a third party to the proceeding has filed or not.
No,
I inquired.
Video appear on behalf of Mr. Myla, this, that.
So,
Whatever is the difference, that's a merit.
let's say I file a review application on behalf of the Jila Parishad Lordship. Jila ADM 8 Lordship.
You were a party to the proceeding. That's all. We just wanted to know that
Lordship.
for the purpose of the condonation, nothing more than that.
Lordship.
On consent allowed, but review we have to.
Well, here now, today, your lordship, because of my item is appearing.
Lordship, contempt is
Yes. With an application for condonation or delay in filing the instant review application beyond the statutory period of limitation provided therefore. The grounds, the reasons for delay has been enumerated in the instant application, which according to the petitioner was beyond their control. Stop. It is further stated that the petitioner was all along diligent and careful in proceeding with the instant matter, and no lapses or latches can be attributed to its conduct. However, the counsel appearing for the respondents herein submits that the delay may be condoned, but insisted for taking up the review application, which according to him does not contain any grounds warranting the invocation of the review judge. So in view of the above, the application for condonation or delay is allowed on consent. Let the review application be formally registered. Now tell us on merit.
Contempt application. Already contempt application filed.
First, tell us on your review application.
Yes.
You are moving a review application. Tell us.
Lordship, first Lordship. Lordship, paragraph Lordship. Lordship, order Lordship, kindly see. Page 64, paragraph 9, Lordship. It is Lordship order, Lordship.
The order dated 29/4.
Lordship.
Please tell us the internal page.
Internal page. Internal page.
At the bottom you will find
5, Lordship.
5. Yes.
Paragraph 9, Lordship.
Paragraph 9, sir. Yes.
It is contained by the applicant that despite the discharging the duties of Sahayak, she was not paid the remuneration as admissible to her. After the concerned authority turned deal her to her repeated appeals to clear that area honorarium of such and such, that's the repetition file 2014, Lordship. Lordship, this order, I file an appeal. The Jila Parishad have challenged this order and file for appeal, Lordship. Lordship, last Lordship, paragraph 10, Lordship, clearly, Lordship, admitted no appeal was preferred the state against such order dated such and such. This order file an appeal before this honorable court.
From the record, please show us that you have disclosed that you filed a
Lordship, mysterious facts that
Mr. Counsel,
Lordship,
please show us from the record of the writ petition that you have disclosed that the appeal was filed.
Lordship, 1 minute, Lordship. Lordship, mysterious fact, Lordship. Lordship, this earlier writ petition, the nodal officer of the certain Jila Parishad is a party, but this writ petition is not a party. So is no knowledge, Lordship.
Please show us that you have disclosed in the pleading that an appeal was filed. From that record
Lordship. Report, Lordship.
of the writ petition. Means your writ petition, it is an amity. Yes. The writ petition from which this amity originates, show us that writ petition, not the earlier writ petition. that writ petition that you have disclosed this fact.
That writ petition, I have not annexed this, Lordship.
You are seeking a review on the ground of error apparent on the face of the record. What the court is supposed to know?
This writ petition is annexed. This appeal is filed 1782, Lordship. 2015, Lordship. I have annexed this writ petition of that appeal, Lordship.
I just wanted the writ petition
Earlier,
from where MET 987 of 2021 was filed. I wanted that writ petition.
You see, that writ petition.
The MET is there. No, he is
Lordship,
talking about this
as
fact.
Lordship. If Lordship, kindly my paragraph is says, Lordship.
Should be WP something. It has to be. This is preferred.
Paragraph.
It is actually passed by the same WP. This is the rest.
Lordship, Lordship, 1 minute, Lordship.
Show us the copy of the writ petition filed in WPA 6378 of 2016.
60.
He wanted that. Or any opposition filed, reply filed shows.
Let's see, one.
May I shortcut my lord? Only one thing. Only one thing, my lord.
No, no,
My lord, against that appeal, they have already complied with, my lord, before the Honorable Justice.
We do not want that. He is saying that there is an error.
No,
Let
no,
us see.
one point, Lordship.
Disclose whether it has been complied with or not complied with. We are not concerned with that. We just wanted to know.
Lordship, 1 minute, Lordship. This writ petition 6378, Lordship. The nodal officer is not a party of this writ petition. Earlier writ petition, nodal officer party and same file an appeal. So that is
Now tell me. First hurdle cross. A person who was not party in the writ petition or in a mandamus appeal, can he file a review application?
No, that's appeal filed. Nodal officer and Lordship, that's appeal filed by the nodal officer and executive of the Lordship. Lordship, দুজন আছে। Lordship, that appeal file nodal officer and executive officer Panchayat Samiti. I filed an appeal before this court, executive Jela Parishad and Panchayat Samiti, Lordship. But one is Panchayat Samiti is a party of this earlier writ petition and this writ petition, Lordship. Lordship, Panchayat Samiti party earlier.
Show us that writ petition, sir. No, let him point out. We are not going to read the whole of it. Let him point out from the writ petition that you have disclosed or in an opposition you have disclosed. Anywhere, any pleadings of the WPA which is there, 6378, any pleading, opposition, reply, supplementary affidavit, whatever, you have disclosed this, that you filed an appeal. No difficulty. Sure.
My point, Lordship, before your Lordship, this writ petitions, Lordship, this writ petition number
6378.
Lordship, this writ petition, the nodal officer and executive officer, nodal officer is not a party and executive officer is Panchayat Samiti party, Lordship. This is earlier writ petition, nodal officer party and executive officer Panchayat Samiti.
Sir, I am asking you one, we are not dumb.
No, Lordship,
What you think is,
I understand, Lordship, I'm not.
it appears that you do not know the jurisdiction of a court under review.
Lordship.
You have no idea that how far the court will go and entertain a review application.
No, Lordship, that's
you are arguing something which we believe is not incorporated under Order 47, Rule 1 of the Code. We are asking you that on what ground you are doing it. Under what grounds a review is permissible? Tell us. First, let us go very academically. Let us understand
I point out this
on what ground the court can review its own order. Tell me first. Tell me.
I mentioned this as a chapter 2 ground, Lordship. One ground.
Forget
Plus,
about
I
it.
understand.
First, tell me the law that on what grounds the court can review its jurisdiction. It's a pure question of law.
Lordship, that's the writ petition. I have not filed any application. Opposition, Lordship. So, Lordship is. But earlier writ petition.
Sir, I am not going into the merit of the
Lordship,
case. Sir, we are asking you a law point. A question purely based upon a law. We are again, last time we are repeating. First, we have to understand that what are the grounds enumerated in the statute for review. What are the parameters when the court can exercise the review jurisdiction? I just wanted a law point. What are the grounds of review recognized in the statutory provision? We are asking you this simple question, sir. Forget what you have said. We will go into the merit later on. First, let us understand the law. What is that? Show us. Tell us. Tell us what is the law.
Earlier writ petition, Lordship, I not to file any objection, Lordship. So there is no chance.
Is this a ground for a review? Tell me. Is this a ground for a review? Tell me.
2 point I mentioned, Lordship.
Again, I am asking you,
Lordship.
sir. Tell us whether it is a ground for a review. You were not given an opportunity to file your opposition. Ground for a review. You were not made a party.
No.
Is a ground for a review. Tell us.
I am a party, Lordship, this matter.
You said that one of the applicant was not a party.
Lordship.
One of the applicant is a party. Sorry, another applicant is a party. I can understand.
No, sure. No, this appeal filed by before this court that I am a party of this appeal, Lordship. But Lordship, earlier.
We are not concerned with the earlier one. We are concerned with this matter. Tell us, if you were a party, then what are the grounds of review?
I mentioned these 2 grounds. Let's say one is not a party, another is a.
Can this be a ground for review? Tell me.
That is the 2 ground. Otherwise, I not mention this any ground.
Tell us that this comes within the purview of the review jurisdiction. Tell us. We are ready to accept. No difficulty. Our mind is still
Lordship,
open.
I have mentioned this.
Our mind is still open. If you satisfy us, we will definitely look.
Lordship,
I think my brother will also join. If you satisfy
Lordship, I
us,
mentioned this 2 point, Lordship, 12, paragraph 12, 13, Lordship.
You may. Now, these 2 grounds are the good grounds for review. I am asking you a law point. Let us take that these 2 grounds are there. Good grounds. You have rightly raised this now. Whether it can be raised in a review jurisdiction, I am asking you. Tell us, show us the law.
Lordship order passed, Lordship, 1 minute. 29/4/2022, Lordship. Lordship order, Lordship. That's order, Lordship. I will not appear this matter. So I am saying that another appeal is filed, Lordship. In absence of Jila Parishad, this order is passed, Lordship. So I cannot say that.
So you are not ready at all. You are not ready at all. You have not applied your mind on the matter. Whatever has been informed to you, you are, may I use the term? We are asking
Lordship.
that what are the grounds which are enumerated for review? On what circumstances, understand? And then you say that under this bracket, I am saying that these grounds are coming from this bracket. It will not accept fire accept, but it will not cause the grounds. What are the grounds of them? Every matter will not be reviewed on this grounds on which the review. What are the
So I'm saying to
You have not really prepared yourself. Tell us when you can prepare yourself on all. Tell us.
80 something. Okay.
I have been suffering since 2000.
No, if such review,
I have not been allowed to join in spite of proceedings.
Yes, contempt application is pending.
57.
After vacation,
You will take such a time. Then the contempt will proceed.
I collected the copy,
Then
read petition, another
Then
copy.
we will proceed with the contempt.
No. I collected the read
They
petition.
will give it to you today itself. Get a
Here in the
photocopy.
my copy I am giving.
No, one photocopy you give it to.
Next week or
My lord,
next week.
Friday, my lord.
No, Friday.
Aged amount,
Friday. Today you give.
Friday, another day. Friday.
Friday. Then Thursday.
My matter is
Yes, then Thursday.
one limit I think my matter is fees another good.
Then come on Saturday.
No.
Come. Do it on Saturday.
I read because of the I have been suffering.
Either Thursday or Friday. Not beyond that. Tell us. Any day.
15 तारीख 13 तारीख दादा मैं देखती
Is not 13th. The Friday is 15th.
Lordship 19 Lordship.
No, 15.
15 and 18 my matter is fixed with the commercial court Lordship.
As 14 come.
14.
Is not fixed. 14. Yes.
11.
Let this matter be listed on 14. Now, give a copy today.
I am here.
No, there's a noting. What are you doing it? You keep a copy with you. Make a Xerox photocopy and give it to him. Ask his where he sits.
I know. My lord.
Before recess. During recess.
My noting is given. My lord.
Where is another copy?
I am giving one copy. He will take the photocopy. Then he told me that I will take.
You wanted everything. Do it by yourself. What are you? If he says so, come.
If such review is not allowed,
if he says so, come.
If such review petition is not allowed, I am taking instruction department within 15 days. All are.
Sorry, however, the council for the review applications says that he does not have a copy of the writ petition.
Well, she appear. A writ petition is
Writ petition from which the order, from which the mandamus appeal originates, and therefore unable to assess the court on the queries raised in course of the hearing. In order to obviate such difficulty, the respondent in the review application is directed to serve a copy of the writ petition upon the learned advocate for the review applicant in course of this term. And then is the matter.
My contempt along with.
So now there is an order. He can't say no.
My contempt will appear on that.
Let us be called.
Copy
My lord, I'm clearing for notice with my lord. Petitioner's advocate, Mr. Tapan Roy, is not able to come to court, my lord. So,
Whole week he will not come to the court.
no, my lord.
Whole week.
Milord,
1 week, my
this
lord.
is
One,
No, the entire
Milord,
this entire
Milord,
week he will not come.
no, my lord, he is suffering for fever, my lord.
Milord, this is review application, Milord. Kindly adjourn for the day, Milord, because I am the circuit bench, I am the counsel appointed to move this matter, Milord. And Milord, kindly adjourn for the
But
day.
the
I shall come back.
no, you are asking for time.
Mr. Tapan Roy,
He is appearing for whom?
petitioner, my lord.
He is saying that he is for the.
He is senior, another advocate, my lord. He is Mr. Satyajit Sinha Roy.
So he wanted only not today, and you
Okay,
are
my lord.
saying not this week. That's the
My lord,
first
Mr.
settle your course with him.
Only not today,
Only not today, my lord.
only
Not today.
not today, Milord.
Not today.
Grateful, Milord.
Petition.
85 for that. 55 to
Review application.
no contempt evidence service will not complete.
Contempt
My lord.
255.
Same matter that is
When that is fixed.
my lord.
When that matter is fixed.
Fixed 20 কত বলতে জানো শুনিনি
22nd, Milord, 22nd last day, Milord.
No. This is connected matter with the review.
My lord.
Yes.
When the review application is fixed.
Yes.
22nd
22nd.
কবে দিয়ে দেন
22nd.
You did not appear.
my lord appear
Then have you not heard?
my lord date was not
What is that serial number?
serial number
250, 51. 250, 251.
250 and 251.
So
not-
both have been on 15th. Let this matter be also listed on 15th. Yes.
15.
List the matter on 15th.
Milord, super.
15th come.
In the meantime, Milord, it is
15th you come.
Milord, my humble submission that Milord, so far my knowledge goes, Milord, it is fixed on 22nd. Milord,
Oh.
as a matter of we have
My court officer says on Friday.
we have to
Friday. That is on 15th.
as a matter of we have
Yes,
to file
yes.
section 5 application, Milord.
He said that within 2 days, if you have to put in, if you do not, then we say that also file, let it be listed on 15th. Yes, call the next.
কি করে ফাইল হয় বলুন তো? As a matter of fact, my humble submission, Milord, let it be fixed on 22nd.
Sir, your senior was here. Your senior has heard it.
Senior also hard.
Sorry, no, he has not.
Fixed on
15th,
22nd,
15th
Milord.
we have said. Yes, next.
Milord,
256.
Milord, I appear for Milord the writ petition applicant. Milord, a contempt has been committed.
Lord, I was praying for this.
শুনিয়েন নি
এই,
তাহলে পরের শুক্রবার করুন না এইটুকু করুন আমি আর কিছু না পরের শুক্রবারটা করুন এটা আমার রিকোয়েস্ট আর কিছু না আর ডাক্তার
টাকা পেয়ে গেছে। Lord, I was praying for this, Lord. I am the alleged contemner. If your lordship would take up the matter any day after the vacation.
After the vacation, Milord, I have Milord. If your
appearing
lordship
for
takes it up,
Lord, I am having alleged contemner.
I am for the petitioner, Milord. If your lordship
Petitioner means
Shubhra Rai, Milord, the writ petitioner.
The passport, she was
Contempt petition, I am the applicant.
employee in the passport office, Lord, and then her upgraded payment has been made. Only that
Milord, I do not wish to make any comments since he is not armed with Milord with any brief and the junior. Since Milord, I have a deepest regard for him. The fact is, reality is otherwise.
deep or deepest?
Deepest. That is why I do not. I say, Milord, that the reality is otherwise.
So what he,
But he says, my lord, the after vacation, which I, my lord, humbly requested him not to do this. My lord, I am under tremendous pressure, my lord. Every day, my lord, 2 phone calls. I am, my lord, really.
Lord, I was praying for this. I tell you, I was.
My lord, this litigation is ultimately, my lord, if I can say so, if I may say so, my lord, the last kick of a dying horse. No, my lord, otherwise it is not a pursuit of any fancy or passion, my lord. It is, I want to achieve a practical ends. So, my lord, if your lordship permits the other, ask, my lord, to come before your lordship on 15th. Because otherwise, my lord, the 15th, my lord, Mr. Chatterjee, my learned senior friend, my lord, at least, my lord, he will not have any difficulty, my lord. At least, my lord, in this, because it is between the contemptor and the, I am, my lord, absolutely, my lord. Contempt, they have a filed affidavit. I request your lordship, my lord.
No, client is here. Client is in Calcutta now.
They have filed affidavit. They have exchanged. I'm strong.
He's in Delhi. He's in Delhi.
If your lordship takes it up on 15th, my lord, I would be
Next week, any day next week I will do.
Monday, 18th. I'm extremely grateful. I am deeply obliged to my learned senior friend.
Grateful.
Hey, Ajay Kumar Chatterjee, senior.
Lordship, in this matter, Mr. Pankaj Jaldar was just appearing, my lord, in item number 253. This is the contempt, my lord. Petition. My lord, sorry, my lord.
when that other matter is fixed,
My lord,
this is a contempt application.
yes, my lord.
And review application is also filed.
Just my lord fixed this.
When that is fixed, review 14 December. So let it appear on 14th also.
Very well. Obliged, my lord.
Let's call the next.
I appear for Miller the alleged contemners. Or not all. 1 and 2.
What you have? Why you have not complied the order?
But I have filed an application for recalling extension of time for securing compliance, Miller, where a disciplinary proceeding was directed.
Where is that application?
Miller, that application, this application came up before his lord, the division bench presided over by Justice Talukdar, as his lordship then was. The bench says it should be taken up by the coordinate bench having determination. You pass the order. Now, Miller, your lordships were of the opinion, sitting with Justice Samanto possibly, that no, this should go to regular bench. My application for extension, Miller, should.
Which is the regular bench?
Regular bench, court 8, presided over by Justice Shomenchen.
So then
And this contempt, Miller, they are saying that I have violated, Miller, the order passed by a division bench presided over by your lordship. Now, Miller, this should be taken up together. Since your lordship is taking up the contempt,
give that application, let us see. Number.
application number একটু বাদে দিয়েছি আপনাকে আছে এখানে হ্যাঁ এইটা এইটাই ঠিক আছে বলো দুটো কথা বলো বলো না তোমার যে অভিযোগ বলো compliance.
My lord, kindly, my lord. Kindly, my lord. Kind of.
বলো মুখ ফুটে বলো না দুটো
my lord, on behalf of the my lord, applicant, my lord, I am praying, my lord, only not to do my lord.
No, we are directing this application to also be to be listed. So it is listed application.
Matt is there, but it's application.
Contempt না ওরা একটা application for extension of time কোথায় আছে?
আমরা একটা extension of time করেছি না?
Give that number.
হ্যাঁ দিয়ে দিচ্ছি 2 minutes. May it appear in the next week?
He is asking for not today.
Next week করো
My lord, next week, my lord, kindly.
Yes, next week. Yes, next.
In this matter, madam, I am appearing for the applicant. This is the first time this is appearing.
Then serve the copy and come back 1 week after service. Next.
So this is my contract application, my lord. This is also the first time, my lord.
Service, come back.
Come back on
1 week after. Contempt petition. Update. Yes, yes, everything is over. Correct. So we will be taking up order 41 from 2 p.m.
But I have my first matter, my lord, that matter which my lord was hearing, my lord.
Which one?
My lord, that probate matter, my lord, where the bar is attracted, my lord. I've come up ready, my lord. There is a fixed matter at 2 p.m., my lord. I was waiting from the morning, my lord. May I, my lord, only say, my lord, to
Only application. You did not respond when the matter was.
No, my lord. The first matter of order 41, my lord.
So it will be from 2 p.m. We have already
matter,
said.
my lord, in court number 6, my lord.
This is a senior bench.
My lord.
So
State respondent.
My lord, I beg to appear on behalf of the appellant in item number 2, my lord. My lord, I am led by Mr. Parthasarathy
It
Bhattacharya.
is one which is called
Blood, there is a cross appeal.
item number 1.
Our appeal, the High Court Administration's appeal.
Hmm.
And blood, item number 2 is the appeal by the writ petitioners. So against
Both
the
are aggrieved by same order.
same order, but the area of being aggrieved is different. So far as High Court Administration is concerned, we have come up only against the portion of the order, because blood, our contention has been upheld, but not only a portion which has gone against the High Court Administration. We are before the division bench.
Lord, only thing which I will be drawing to my lord's kind attention, that the special leave petition is pending, and my lord, today up to my lord, I have brought the list. My lord, it has been called up to my lord. I am awaiting my lord for in the online my lord. This is item 46 in
That
today's
must
list.
be against the interim order which was passed in the appeal, not admitting the appeal. My learned friend is aggrieved by that. I take it.
We have filed a special leave petition against a order which was passed by this court in the matter, and my lord, that my lord, we have drawn to the attention of the Honorable Chief Justice. And my lord, it appears, my lord,
It
that
is listed today.
this is listed at today, and my lord, up to kot of the item hoyeche?
27.
Up to 27, the matter has been called before the bench of Justice Rishikesh Roy.
ঠিক আছে, পরে হোক না, ঠিক আছে। যা হয়ে গেছে তো জয়েন করে গেছে।
So when we can fix the matter, obviously after the matter is taken up.
Absolutely.
So next week.
Any day, my lord. I have
Lord, insofar as the appeal is concerned, Lordship will kindly fix it, Lord, any day convenient to your Lordship.
No. Suppose if
No,
the
no,
order of admission as it says goes, then
Lord, that is against the interim order, where Lord, the division bench had said that these incumbents, successful incumbents, will join subject to the result of the appeal.
Okay.
That is against that order. Here they have gone to the Supreme Court. In admitting the appeal, this is the interim order that was passed. That Lord, the incumbents who are successful, they will join subject to the result of the appeal.
we have been given to understand that against an interlocutory order passed in the instant appeal, one of the party has approached the apex court with an application for special leave special leave petition, and the same is listed today.
পুরোটা লিস্ট আনতে পারতি, জজ ওইভাবে কি করে নামটা লিস্ট হবে?
In view of the above, let this matter be listed on next Tuesday.
Tuesday week.
Tuesday week.
Tuesday week means holiday.
No, I submit, my lord, that supposing
we are on Monday.
if the business I am awaiting in the online,
Then
my
you
lord, I
come
will
and
be.
tell us on
Yes,
that
yes.
day whether
The
when
matter has been
next
taken up or not.
next date is fixed. At least
I'm
this
grateful.
much. Wait for today. You don't know. Matter may be taken up
Yes, yes,
tomorrow
yes.
also. At 2 p.m. Watch it.
Same. Two appeal.
Arising is the same.
It can be taken up together because against the self-same
Yes,
order.
yes, of course. It should be taken up together.
এটা order করে দাও that this is an appeal at the behest of the writ petitioner.
Yes.
Item number
Yes.
2. Assailing the self-same judgment and order, which is also assailed by the High Court administration in Agir appeal number 30. Since the said matter is directed to be listed on 19th.
Yes.
Let this matter be also listed on the said date.
Much.
Call the list. Who is for the appellant?
The hardest for last 2 days.
What is the matter?
That is local matter.
Oh,
May I, my lord? Before, my lord, I show that my suit was maintainable, my lord. My lord, some facts, my lord, which are required, my lord, in order to, my lord, satisfy my lords.
which one?
Some facts, my lord, are required to be, my lord, submitted in order to satisfy, my lord, that, my lord, my
Only
suit,
point, again I am repeating.
my lord,
Now, on the other day also,
my lord,
this was raised.
my lord.
Whether the appeal is competent
Yes.
or a suit is competent against an order or award, not order, an award of the Lok Adalat, or the remedy lies somewhere else. I just,
Then, my lord, may I satisfy on this point first, my
that
lord?
is what is the only point.
My
If your suit is maintainable, no problem.
My lord,
If your suit is not maintainable, then
I will.
any order which is passed in a incompetent suit has to go.
But with regard to that, my lord, the previous suit, my lord, in appeal whereof, my lord, this honorable court was pleased to, my lord, set aside that decree for partition. My lord, that order was, my lord, not only, my lord, was appealed, but it was admitted by all the parties, even my learned senior friends' clients. And thereafter, my lord, a partition suit was filed on the basis of the will, not on the basis of the probate, but on the basis of the will, wherein probate was granted in other terms. The beneficiaries were different in probate, the beneficiaries were different in will. Partition suit filed, my lord, with regard to, my lord, probate was dismissed, my lord, by this honorable court, and thereafter subsequent partition suit was filed on the basis of the beneficiaries of the will, where upon whom, my lord, the probate was not granted. And that, my lord, was, my lord, disposed of by on the basis of a, my lord, compromise, my lord, by way of a, my lord, award passed by Lok Adalat. Now, my lord, I'll 3 or 4 judgments, my lord, 3 judgments which my learned friend, my lord, has cited, or rather my lord has, my lord. But all those 3, my lord, I have seen, my lord, have, my lord, followed the, my lord, 2008 2 STC 660. That's, my lord, the case of state of Punjab and another versus Jalor Singh and others. Lord, may I, my lord, that judgment is, believe, my lord, not with my lord, may I, my lord, show those 2 judgments. Because, my lord, even, my lord, the Bhargavi construction took note of it and thereafter declared that.
And our 11, 12 very well significant. 11 and 12 is very significant.
What?
My judging, my friend is relying upon paragraph 11 and 12 very
Yes,
significant.
sir, I'll say, I'll see the thing. Before that, may I once read, my lord, section 21? Once, my lord. Section 21, my lord, I'll only read the subsection 2. That's, my lord, every award made by a Lok Adalat shall be final and binding on all the parties to the dispute. And no appeal shall lie to any court against the award. But I am focusing on, my lord, all the parties to the dispute.
Sir,
Now, my lord, if my lord may kindly takes up 2008 to SCC 660. Paragraph 12, if my lord may kindly comes. Paragraph 12. Firstly, may I say, my lord, the facts, my lord, that all the parties to the compromise were the parties, my lord, in this case. No third party was involved in this case. Kindly comes to paragraph 12, my lord. It is true that where an award is made by the Lok Adalat in terms, my lord.
Yes.
But this paragraph, my lord, says that it becomes final and binding on the parties to the settlement and becomes executable as if it is a decree of a civil court and no appeal shall lie. And after, my lord, it says that if any party wants to challenge such an award based on settlement, it can be done only by filing. So, my lord, I say, my lord, this binds, or my lord, this becomes final, my lord, to the parties who are there in the settlement. Even section 21(2), my lord, says about the parties to the dispute. Well, I was not a party to that suit, my lord. But I have, apart from that, my lord, I have never availed, my lord, or my lord, never submitted to the jurisdiction of, my lord, the Lok Adalat, or my lord, which is coming under the Legal Services Authority Act. So, my lord, that cannot bar me, my lord, from filing a, my lord, fresh partition suit. And I have tried to, my lord, apart from that, my lord, may I firstly complete the judgments. My lord, Bhargavi construction also, my lord, in paragraph 23, after taking note of, my lord, this paragraph, the paragraph 12 of the 2008 judgment, quoted it, my lord, in paragraph 23 and 24, my lord, has said that the, my lord, the only remedy available to the aggrieved person, that was the plaintiff. That person was a plaintiff to the, my lord, suit, who wanted to challenge, my lord. But here also, my lord, no third party was involved.
Yes.
Apart from this, my lord, the other two judgments, my lord, I'll not take, my lord, to those judgments, my lord, 2008, 22, volume 8 SCC, and my lord, 2022 8 SCC 140, that's my lord Hemanta Kumar, and 2022 9 SCC 516, that's New Okla Industrial Development Authority. In both these judgments, my lord, the third party's case were not involved, my lord. This was not decided, my lord, that if someone who is outside of that, my lord, award, or if someone is a third party to it, my lord, is also bind, my lord, by that Lok Adalat award, my lord, and cannot, my lord, and has to challenge it, my lord, only before the, my lord, 226 or 227. My lord, I have tried to find out, my lord, the cases, my lord, where, my lord, this point has been involved. Not of Supreme Court, but I've got a judgment, my lord. Two judgments, my lord, one of Kerala and, my lord, one of Madras High Court, my lord. With my lord's liberty, may I, my lord, rely on this, my lord. This is a single bench judgment, my lord, may I say, my lord. Paragraph 10, my lord. Yes, ma'am. আমি দিয়ে দিচ্ছি, এক্ষুনি দিয়ে দিচ্ছি, একটা কপি দিয়ে here, my lord, a two, my lord, paragraph starting from 2010, my lord.
10.
But here, my lord, a third party has filed an application, my lord, a writ under Article 227, my lord, before the Honorable High Court. Paragraph 10, may I read, my lord?
No, just give
My
us.
lord. 10 onwards, my lord.
Yes.
Not one another case, my lord, that's of, my lord, Karnataka High Court, my lord, that's reported at, my lord, AIR 2001. Karnataka 407. Here, my lord, the appellant was, my lord, party to the suit, but was not party to the compromise. But ex party, my lord, Lok Adalat award was passed. My lord, he has filed an Order 9 Rule 13. Order 9 Rule 13 got rejected, my lord. Thereafter, he has approached High Court. But finally comes to, my lord, paragraph.
What the High Court says, maintainable.
No, with regard maintainability, with regard to maintainability, the court has not said anything, my lord. With regard to, no, my lord, they have prayed for certiorari. I must say, my lord, they have prayed for certiorari.
You said Order 9 Rule 13, that's
Yes,
why.
Order 9 Rule 13 was filed, my lord, that was rejected on the ground that you avail the 226 or 227 jurisdiction. My lord, why I am citing, my lord, only to show, my lord, the effect of such, my lord, Lok Adalat award, my lord, which has been, my lord, made, my lord.
What it says, it's a compromise or it is an independent award?
It was a compromise by some of the parties.
But that runs counter to the Supreme Court judgment. Supreme Court says it's not a compromise. That's why on the last occasion I said that whether you term it as a compromise or you term it as a award under Section 21. Supreme Court has said it is not a compromise. Which is the judgment? New Okla or Hemant Kumar, which one?
2022-9 it was. Okla was 2022-9.
Yes.
Even in this, my lord,
the Supreme Court has said something differently. It says no. It is not a compromise.
but that was, my lord, in the nature of, my lord, their, my lord, Land Acquisition Act, my lord.
No, whatever is
determination under Section
that
28A
the
was.
question was very much involved that it is under Order 23 Rule 3 or it is under Section 21 of the Legal Services Authorities Act. And the Supreme Court has said, I believe, if my memory goes right, then it says no, it does not take the character of a compromise.
In my case, my lord, it was under Section 21 because, my lord, the court has not applied
true,
its
that
mind.
is- yes. Yes, paragraph 62 of the new Okla. So this single bench judgment has not really goes counter to this judgment.
Yes, my lord.
Supreme Court judgment is binding on us.
So that says, my lord, that it is an award under 21.
And not a compromise.
Yes, my lord, because the court has not applied its mind.
So the Karnataka High Court has had compromise. So if it is contrary to a Supreme Court judgment, then we are bound by the Supreme Court judgment than any other High Court judgment.
And the court has said in
And
this case,
paragraph
my lord,
64, 63, 64, elaborately discussed.
the court has said that the Lok Adalat, the settlement which was arrived, my lord, on the basis of compromise before the Lok Adalat.
No, it is not. Paragraph 63 says that an award passed by the Lok Adalat is not a compromise decree. An award passed by the Lok Adalat without anything more is to be treated as a decree inter alia. We could approve the view of the learned single judge of the Kerala High Court in P.T. Thomas. An award, unless it is successfully questioned in an appropriate proceeding, becomes unalterable and non-viable. In case of compromise falling under 23, it becomes a duty of the court to apply its mind to the terms of the compromise. Without anything more, the mere compromise arrived at between parties does not have an imprimatur of the court. It becomes a compromise decree only when the procedures in the courts are undergone. Then an award passed under Section 19 is a product of compromise, sans compromise. The Lok Adalat loses jurisdiction. The matter goes back to the court for adjudication. The pursuant to the compromise and the terms being reduced in writing with the approval of party, it assures the garb of an award, which is in turn is again deemed to be a degree without anything more. We would think that it may not be legislative intention to treat such an award passed under to be equivalent to an award of the court, which is defined in the Act as already noted and made under Part 3 of the Act. An award under Section 28A is to be treated as a decree. Such award becomes executive. It is also appellable. Part 3 contains a definite scheme. This is how they gone in a land acquisition case. So it says it's not a compromise.
Yes, my lord, but
It
will be
has
treated
it partakes a character of an award, which is akin to a decree and executable at once. Now once the Act says that this is final and cannot be assailed by way of an appeal. So the right of appeal has been taken away. The apex court in those judgments, these 3-4 judgments, all in tune, says that yes, you can go under one Article 226 and 226. So I think the Karnataka has no relevance to this.
Since in all
I can understand the other judgment.
but since in all the cases, my lord, delivered by Supreme Court, my lord, the judgments, my lord.
No, we understood that you want to make a distinction between the expression parties to the proceedings and a parties dehors the proceedings. Parties to the proceeding means the parties who were there before the Lok Adalat for a settlement. So if it is between them, it is binding upon. But a party who was not there, then any settlement that has arrived, that will not come under the purview of this and cannot bind it. That is what your
My
contention
lord,
is.
with
You
regard
wanted
to
make
bar,
a
my lord.
Yes.
This is what I submit, my lord. My lord, apart from that, my lord. If I have an, my lord, on the same lining, my lord, that if I have an independent right, over the property and I have not been made a party, my lord, on the same line, my lord. My lord, can it bind me, my lord, or can it, my lord, stop me, my lord, from filing a suit for partition, my lord? Because, my lord, suit for partition, my lord, as my lord, recurring cause of action, my lord, and it, my lord, even, my lord, there is no principle of res judicata, my lord, in suit for partition, my lord. In the sense, my lord, I'm saying, my lord, in the sense I'm saying, my lord, even if there is a partition suit, my lord, wherein, my lord, all the co-sharers have not been involved. The other co-sharers, even one of them, my lord, have been left out, my lord, can maintain a subsequent suit for partition, my lord, involving every co-sharers, my lord. My lord, may I also say, my lord, I was also going through some judgments, my lord, the question arose that if a suit for partition has been filed subsequent to proceeding of a grant of probate, whether that remains to be stayed only because there is a will. No, my lord. So, my lord, what I want to emphasize, my lord.
Even you will find a judgment to that extent that even if the probate has been granted, the parties have filed a suit for declaration of their title, dehors the grant of probate. The suit is maintainable. There is no difficulty. Who says that it cannot?
My lord, what I'm, my lord, trying to impress, my lord, the suit for partition, my lord, which was filed, on which, my lord, this Lok Adalat award has been passed, was filed by the persons, my lord, on the basis of the will. That's not on the basis of the probate. In the will, my lord, 5 persons, my lord, have been bequeathed property, my lord. Three of them, my lord, 1/4 each, and 2, my lord, 1/8 each. Someone else, my lord, whose name is not there, has been granted probate. of 50% of the share, my lord, of the suit property in the probate. On the basis of that probate, my lord, filed a, my lord, suit for partition. That was preliminary decreed, my lord. This honorable court, my lord, has set aside that decree and said that until and unless you are having title, you cannot maintain a suit for partition. You are at liberty to file a independent suit claiming your portion in execution or in terms of the registered agreement, the private arrangement, my lord. They have filed that also, my lord, on the basis of the probate. My lord, that has also been dismissed on the principle of res judicata. That was also dismissed on the principle of constructive res judicata. Thereafter, my lord, second suit was filed saying that since the probate has gone by the order of this honorable court, they have accepted it, my lord. This is the pleading. As such, the court is of the view that the beneficiaries of the will has to be given effect. My lord, the will has to be given effect to. As such, my lord, according to the will, my lord, the persons who are, my lord, getting the, my lord, property, my lord, as per that will, which was not probated on that terms. As per that, my lord, they have, my lord, filed a suit for partition. My lord, Lok Adalat award has been passed. A will, my lord, which was not probated, my lord, they have filed a suit for partition on that basis. But may I show, my lord, copy of the plaint, my lord? My lord, so permits, my lord, copy of the plaint, my lord.
That you said that it is
Yes.
on that basis.
And they are the same persons, my lord, whom, my lord, my learned friend is, my lord, representing, my lord. So, my lord, now, my lord, there is stopped from saying that the probate still remains there. When once on pleading, they have, my lord, applied to the court that that probate has gone. Now we are claiming through the will, which has not been probated in terms of the will. And, my lord, in that, my lord, Lok Adalat award has been passed. So, my lord, a will which has not been probated, my lord, may I say, my lord, according to, my lord, inheritance, my lord, since, my lord, that was will of 1960s, but not probated till date. But I have, my lord, filed a suit for partition as per, my lord, inheritance.
That's all.
These are the pleadings, my lord. Now for the my lord, I was appearing for response number 1 only, my lord. That's recorded, my lord. You know, but may I say, my lord, that my lord, now, my lord, is, my lord, a hearing, my lord, on order 41 rule 7, my lord. So, my lord, kindly, my lord.
Respondent number 1 is a plaintiff.
Yes, my lord. One of
Is
the
the alone.
one of the plaintiff.
One of the plaintiff or the plaintiff alone?
No, one of the plaintiff. Yes, on behalf of the plaintiff, my lord.
So,
though, my lord, Vakalatnama, there was a caveat on behalf of respondent number 1 only, but we have instructions.
yes.
That's true. My lord, maybe
Let us hear him.
documents are also, my lord, we are yet to, my lord, file any opposition, my lord. It's subject to what, my lord.
In an appeal against the injunction order, you want to file an opposition.
No, my lord,
What are you
very
talking?
well.
You have already filed they have filed the pleadings and everything has been done. Yes. Yes, sir, Mr. Goshal, what do you say?
One thing, my lord.
I don't know. My friend naturally is trying his best to make out something out of nothing. But
No,
what
no,
is
the
very
only
clear.
point which he wanted to raise here is that so far as the award passed by the Lok Adalat is concerned, definitely according to section 21, it is binding. But binding between whom? It is binding between the parties. But the parties, what he wanted to say is the parties to the suit or a parties who are before the Lok Adalat. But a third party cannot be bound by such an act. And this, the Kerala Madras High Court has made a distinction. It says that the award partakes a character of a decree, and there is no fetter in law that a suit can be filed saying that the decree is not binding on him, on the plaintiff. Similarly, If a award is akin to a decree or is really blended as a decree, then in that event also there is no difficulty in seeking a declaration that the award of the Lok Adalat is not binding. If I correctly understood, that is what he wanted to argue. You have to say, what is your reaction to it?
First thing is that if there is no established against statute. First, if there is a mandate prohibiting filing of a suit, irrespective of this, no distinction has been made who can and who cannot. My lord has never said, rightly so.
No, 21 says between the parties, the languages, it becomes final between the parties. He read that section.
Yes, my lord, the question is, the question goes to the right to challenge, and moreover, whether the honorable courts of the single bench considered the judgment of the Supreme Court while to distinguish it. Factual distinction has been made or not. How far that has been made by such that secondly, what fell from your lordship, that suppose probate has gone, but the will remains, where the later sisters have been excluded. The spirit is there. And secondly, another suit was there to enforce the terms of the compromise. That should also fail. No appeal against that. Suit after suit. And everywhere they failed. And moreover, they have a remedy, not that, as my lord has repeatedly explained it, told it, that there is not that you are without remedy. You have remedies. But not in this forum. You have to choose a correct forum. You can ventilate your grievances so that the statute does not make you an orphan in that matter. You have every remedy, but this is not the place. It is a usurpation of jurisdiction not conferred by statute. And moreover, the objection will go to so how many suits and they suffered at every stage. No appeal, there's judicata, there's estoppel, and again and again they are coming with the same thing.
Each plaintiff filed partition suit that has been suppressed.
Yes. He himself filed a partition suit. He filed a suit for enforcement of the terms of the compromise.
Compromise by
the present plaintiff.
No, compromise of what? That's the
In terms of the
award of a Lok Adalat.
No.
Then?
Earlier suit that went to High Court. High Court first appeal dismissed, allowed the appeal, setting aside compromise probate. Against that, against to enforce the terms of that thing, that the suit was filed.
No. Mr. Kusal, what are you saying?
I see 486 and 216, they filed another suit for partition. This plaintiff filed over the same fact.
Where that is pending or gone?
Dismissed for default.
In presence of both the parties or in presence of single party? How it was dismissed for default?
But against that, no restoration, no serious.
Please, Mr. Kozal, you know the distinction. I am simply asking, was it dismissed for default in absence of all the parties? Or it was dismissed for default in presence of the defendant?
That minor we have to see that record. Fact remains a suit for partition was filed.
No, that will not do. If it is a dismissal under Order 9, Rule 3 or 4, then there is no bar in instituting a suit.
That is so, my lord. That is, I am not on that.
Order 9, Rule 8 and Rule 9.
Right.
Then there is a bar in institution.
Absolutely.
So that's why I asked. We are saying that the earlier suit was dismissed for default will not do.
I do not mean in that way.
That is what.
I mean to say that this fact has been suppressed. Why is the challenge?
Suppression is not that material because it does not impinge upon if it is dismissed in presence of all, in absence of all the parties.
And moreover, my lord, in the will, my lord remembers, the daughters are excluded. If the
Mr. Ghoshal, if the compromise effected in a probate proceeding is set aside by the by this apex court, means the high court. Then what is denied is the probate to a will, but the will remains. But the efficacy of the will not be recognized by the court under the Indian Succession Act unless it is probated.
Of course.
So the will be mere piece of paper having an emotional or a sentimental value, but cannot be enforced before the court of law unless the probate is granted.
Yeah,
So it will have no difficulty.
But here it is probate was granted.
No, it was on compromise, and the High Court set aside that, says that the compromise is not unknown. The compromise is unknown in a probate proceeding. You cannot alter the ultimate wish. That is what I gather from his argument. I have not opened the brief as of now.
Kindly permit my to explain it further.
This is not correct, man. Prior to the after.
Where is the judgment of the High Court? What it says? That set aside the compromise affected in the probate proceeding.
No, my lord. The High Court said probate court either grant or refuse.
Yeah, true.
So that stands. That stands. They did not. Only.
No. On a compromise, what the apex court has said.
No. The compromise not a part of the probate, my lord. Compromise was not a part of the probate.
So what remained?
My probate granted its own merit.
How can it be? It was granted on the basis of a compromise. What are you talking about? Please.
Page 5 onwards.
That cannot be the subject matter of my lord,
No.
before this court, my lord, and before
Sorry?
this court, my lord. Because, my lord, their only right is to challenge. If it is fraud, even the third party can challenge it by way of 226 or 227. This by suit, this cannot be challenged. He cannot overcome, my lord, the judgment of the Honorable Apex Court. Fine between the parties, but anybody can challenge it before the appropriate forum, not before the civil court. Custodial judgment.
It is.
The decision bench holds that probate stands.
The application lordship at page 10, where 3 and 4 are very important in this question. Paragraph 3 and 4 of page 10 of our stay application. That's paragraph 3 to 6 of our stay application.
Is he claiming a title deholds the will?
The title by itself, unless provided it has got truth.
Deholds the will.
Will by itself cannot confer title unless it is property or not. Because will.
No, I am asking you a simple question. Has he claimed title or see title deholds the will? Because in the will he was excluded. He was not provided. And then by virtue of a compromise, he was provided.
Subject to correction by lordship, it can't be.
So the compromise went. Then says that he is unable to prove his title. I just wanted to know in case of other normal succession or in case of an intestacy, whether he has any right.
No other case is
the
there.
property.
As it stands, no other source of it. His only source is that the will, that is the same common predecessor. And where the lady.
I'm again asking, he is tracing title through a common ancestors means ancestors in case of an intestacy upon the death of the testator will get it. Yes. They are claiming through that.
Yes, common ancestor.
Yes, he is claiming title to the intestacy, which he cannot.
Why cannot?
Pardon
Why
me?
cannot?
In with the will, so long the will is staring at the face.
Will has not been. Even if the probate is granted, even the title can still be challenged. They can go for that.
Yes, while a title by will by itself is not a documented title in that sense. That is subject to the other factors may be proved. But here in this case, no such case went out.
Because it says that the compromise cannot be done. And then ultimately the probate, I do not know what has happened.
But that was about the procedural rigors.
It has been said by the Supreme Court.
Subject to action. Subject to action by Lordship. That was decided by the Honorable High Court on the procedural rigors. So whether there can be provided by compromise or not. Not touching other issues. Lordship kindly, my Lord, can take trouble to see paragraph 3 to 6 of this stay application. We have tried to make it clear how many suits and what are the consequences, what is falling from your Lordship, what happened during all these periods, how many suits and for what purpose. Well, we have tried to make it clear in paragraph 3 to 6. You might not kindly take trouble to consider those paragraphs.
Read that.
Our stay application at page 10, 11.
Please read that.
Yes. Page 3 at paragraph 10. Page 10, paragraph 3. But Vidibhushan Samanto, the original died on 29th June 19.
Testator.
Yes.
Vidibhushan is a testator.
Yes, yes. It is through him that everybody is claiming rather. Vidibhushan died on 29th June 1960 and the probate proceeding was initiated, which has been objected by one of the sons of testator, namely Vishwanath. And after a long contested, the aforesaid probate proceeding has been disposed of in terms of the compromise, whereby objector's son's share has been declared by 8 and such and such. And in pursuant to the said registry agreement dated 5th July 1967, a compromise was recorded. Then, after the compromise degree in the probate proceeding, the said son of Vidibhushan Samanto, namely Vidibhushan Samanto, filed a partition suit, being title suit number 34 of 1972, before under second court of these and second subject at Howrah. And against the judgment and decree passed in the said appeal has been preferred from the original decree being number 364 of 1977. And said appeal has been allowed on contest, and in the said appeal, the Honorable Division Bench of the Calcutta High Court observed the said probate which was ultimately converted into LOA, suit number 50 of 1960, cannot be decreed in terms of Solenama, inasmuch as the probate court is either to grant or reject probate, but cannot dispose of by any LOA or probate in terms of the compromise. Moreover, no suit for enforcement for agreement has also been filed. Accordingly, the Honorable High Court allowed the appeal against preliminary decree for partition, and therefore the decree passed by the latter sub-judge, second sub-judge Howrah, entitled to number 34 of 72 goes. Then, that it appears that thereafter the plaintiff of suit number 34 of 72 being unsuccessful in getting any relief, subsequently filed another suit being number 199 of 1992, praying inter alia for enforcement of the contract, and the said suit has been decided on the question of maintainability and declared to be barred by the doctrine of res judicata. There was no further appeal against the judgment passed in title suit number 199 of 1992, nor there was any appeal against the judgment of Honorable High Court passed in appeal number 364. Now, the plaintiff further state that the defendant thereafter, a suit has been filed by Soprat Samanto, defendant 1, being title suit number 23 of 2011, which is under challenge here, before the second civil judge senior division, praying for suit for partition and declaration, and in the said suit, two sons of late Vidibhushan Somu Samanto and two sons of Ashit Samanto have been made parties out of collusion and have also practicing fraud upon the learned court by not disclosing the judgment of the Honorable High Court in appeal number 364, and observations made therein collusively upgrade the compromise decree in absence of all necessary parties. It is pertinent to mention here that as per the terms of the said will, female heirs, sons of the testator, will not acquire any share in the property which is subject matter of the will as well as subject matter of the suit. However, compromise order of LOA number 50 of 1963 has been said that not has said that short and on any ineffective, and no consequence by the judgment rendered in appeal from 364 of 77. After passing of judgment of the Honorable High Court, no further probate or letters of administration proceeding has been filed by the executor or the beneficiaries afresh. And consequence of non-filing of any such case, the will itself has become ineffective and not proved in accordance with law. Moreover, the suit filed for enforcement of contract being title suit number 199 of 1992 has been dismissed, being barred by the doctrine of res judicata, and the irresistible conclusion is that the will executed and registered at Vidibhushan Samanto since deceased could not be proved in accordance with law, and it will presume that said Vidibhushan died intestate, and accordingly all the female heirs as well as male heirs, legal heirs of Vidibhushan Samanto and his 3 sons and 4 daughters become co-sharers. That is the concept they are proceeding on. That is the plain case. This is the matter how the it has conducted or proceeded with. First a partisan suit, then a suit to enforce.
Interestingly, that the High Court observed that the compromise is only enforceable through a different proceedings, and a different proceedings ended on the ground of res judicata.
Another suit is that independent suit was filed to enforce the transfer agreement that
is dismissed on the ground of res judicata.
What is on
You're
the
talking-
record that was there? But the record is like this, right? We cannot change the record. So this is the position as it stood. 2 partisan suits after that compromise degree. So they made all attempts to do this. Then they failed and they didn't challenge it in the superior forum. It is staring at the face. And as on the date of filing the present suit, this new act, mandate of prohibition is there.
What?
The filing of suit, civil suit is bad under this new act. This, they can go to 226 or 227, but not before civil court. That is under the new act. Very filing of the suit, there is some embargo is there. They can go and file out, they find out to make their grievances before appropriate forum. Nobody can prevent them. But this is not the forum. If they have any grievance, certainly they are not barred to take appropriate steps before appropriate forum. But if so far as this mandate of law is concerned, however, they can go beyond that. That's my only thing I can pray to consider before Lordship.
Yes.
Nothing, my lord. The subsequent suit was, my lord. In that suit, my lord, I can show the pleading. They have accepted that probate has gone. And as such, they are praying for partition on the basis of the intention given in the will.
That
which
is
has
not
been
reflected
provided.
in your plaint. We will consider. The copy of the plaint is here.
Yes, my lord. With me, my lord.
Do one thing. Give us the compilation of the documents relating to these suits, the plaint and the written statement and the order. Can you give a compilation
Yes, my lord.
of all the proceedings?
Not all, my lord, but I have most of them, my lord. I have most of them, my lord. Not all, but most of them, my lord, which will be, my lord, suffice, my lord.
No, you just file it. How soon you can give?
By any time, my lord says, my lord.
By tomorrow you can give?
But only compilation I can give.
Yes, tomorrow. Give.
I'll make an index, my lord.
Do it.
Copy of probate is with us. Just copy.
I have. I'll
Do
submit.
that. You also, whatever you have, you make a compilation and just give it to us with the orders. Let this matter be listed on Wednesday to enable the parties to submit all the relevant documents, including the plaint and the defense and the written statement if filed in other proceedings and the final order passed therein. Wednesday means date दिए दाओ. That is on 30th. Let us see whether the bill survives or a bill perishes. Let us see.
Cannot overcome, plaintiff cannot overcome in view of Supreme Court judgment. That is why liberty is given there. And if anybody agrees,
Supreme Court, there is no judgment. It's a High Court judgment.
no, man, I'm telling you, Jalwar Singh.
Oh.
Jalwar Singh. Fraud, even if fraud, anybody in the world can challenge it, but before the appropriate. Not this. Universe. Anybody in the universe.
Legal maxim is ubi jus, ibi remedium.
Even in that case, my lord, he was a party to compromise who has complained of that fraud.
Yes, call the next. Yes.
36, my lord, I'm for the appellant, my lord. The advocate on record is not present in the court today. He's having high fever. Kindly put the matter after 3 days at least, my lord.
On Friday?
Friday, my lord. Wait.
Come on Friday.
Wait.
This is the matter on Friday. Yes, call.
My lord, I am for the responding. And today,
Come
my
on,
lord,
come on the respondent side.
today, my lord, I submitted the vocalarnama. It was,
Sorry, it is a order 41 matter, FME or SAT?
my lord, in that respect, I am also submit something, my lord. The
No, it is FME or FME, SAT?
FMAT. My lord,
It is a FMAT?
Yes, my lord. It's a FMAT. To that respect, my humble submission is this is a appeal against the first appeal, my lord, of the learned court bill. This should be, my lord, the SAT. So, my lord,
No,
technically,
what
it is not.
is the ultimate judgment? The judgment is the sealed
My
of
lord,
the first appellate court or what?
I don't have the copy of the judgment itself. Section 5, my lord, the appellant will say everything, my lord, but as so far as the record is concerned, it's a FMAT arising of the, my lord, judgment of the, my lord, the learned first appellate court. That is, I am before your lordship, that should have been, my lord. Technically, it is not mental. That is the answer. Lordship.
So it's a categorization. Ultimately, SAT will also lie here.
That.
So it only the categorization.
That can be converted as a lordship. Yes.
देखिए एक बात की चैलेंज হয়েছে
Only by today, the vocalarnama has been returned on the ground that does not on the manner bond paper manner. I'll submit in due course manner.
এটা বলেছি go out of this তখন কেন করা হয়েছে there is an order
Malad, the application of the part of the malad, the tenant
should go out of this section 5 নেই then order 41 এ কেন appear করছে এটা না তো তোমরা দেখবে না অর্ডারটা অ্যাপ্লিকেশন করতে হবে
Malad, in this may I submit
without accompanying so
Malad,
this matter go out of this
Malad, this appeal has been filed on behalf of the tenant and that is there Malad, they are taking that plea Malad, somehow defective plea and Malad, they are taking the advantage of the landed court below without filing any application at all. They are taking that advantage. They filed the wrong caption.
This is against the final order. So how can it be an
And let it be in the list, my lord, the lords is pass whatever the order, my lord, kindly. They are taking the advantages.
No. What I say, sir, you have not. You are misguided by your client. This appeal arises against an order of remand. Order of remand then always registered as FMAT. Cannot be done SAT.
No. Let the matter be listed, my lord.
Section 5 is not here.
But I have copied that.
Okay. No, can 2 is filed, section 5. List the matter as application can do. Order করতে হবে না এই অ্যাপ্লিকেশন ফর কন্ডোনেশন আগে হবে, তারপর তো অর্ডার 41 হবে। কোনটা? আছে ক্যান টু আছে, দেখলাম তো, ওটা তো
My lord, item number 42, my lord. Arthopatim Roy is appearing, my lord, on behalf of the petitioner, appellant, my lord. He is not come to court today, my lord. He is in circuit bench, Jalpaiguri. My lord, in regard to this matter, my lord, one can to section 5 application is pending, my lord. Every video service served, my lord.
Then move it, sir. Move that application.
My lord, 39 days delay, my lord.
Yes, move it. Yes, what are the grounds? Where you have stated the ground? What you have stated? Yes.
Well,
What
I
is the
do-
ground? What is which
Well, I don't
paragraph?
have the application with me, my lord.
So you have come and argues the matter. You are saying that affidavit of service, I'm filing it, 39 days delay. So we wanted to
Previously, it was held, my lord, that my lord asked to file it on the next day, my lord.
You are asking an adjournment or you wanted to move?
Not today only, my lord.
So say that, then you are handing over the service and you are saying 39 days delay. I just thought we thought that you wanted to move.
Only praying for not today, my lord. That's all, my lord.
I'm for the appellant, ma'am. I'm I am the defendant appellant before your lordship, my lord, in a suit for declaration and partition.
30 rupees give.
Yes, my lord.
30 rupees give.
I am not.
Nobody takes care. Where is your clerk?
My lord, by tomorrow it will be filed, my lord.
It appears that the instant appeal has been filed with a deficit court fee of rupees 30, as reported by the stamp reporter. It appears that the instant appeal is filed. Time to put in the deficit court fee is extended for a period of 2 days from date. In default, the appeal shall stand dismissed.
My matter to appear, my lord.
First you deposit.
My lord.
You
My
will
lord.
dismiss for default then?
No, my lord. Today I time today to file this.
I do not know. First you deposit, then mention. It will be listed.
My lord, and Thursday and Friday I will be not here. That's why I'm paying, my lord.
So don't mention on Thursday. Deposit it.
Mr. Supratim Dhar is appearing on instructed by his clerk. He is engaged in some other court. I'm praying for not today only, madam.
Who?
Mr. Supratim Dhar, madam.
Yes. So
He's on his legs, madam. I'm only praying for not today.
shall remain there for rest of the day.
There's a 3 p.m. fixed matter as a instructed by clerk.
Yes.
Grateful, madam.
I appear for my lord.
Partition suit.
46, my lord. It is-
Partition suit.
No, it is suit for my lord, declaration that is, it is a suit filed by the plaintiff challenging a deed executed by his father in favor of his stepmother and stepbrother, stepsister. Lord, Order
You are,
39 rule 1
you are,
expertise.
you are born from the first wife.
First class.
Yes.
Let, order 39 rule 1 expertise in identity model was granted. Subsequently, order 39 rule 4 allowed. Challenging that order, I have found.
Allowed.
Allowed. Order 39 rule 4 allowed.
Which is the order?
Third, first order, I have.
Order number 16 you are challenging?
I'm challenging the order
16 of 12th December.
12 December.
More than a year has elapsed.
That matter was appearing before the another bench. Therefore,
Just
went
wait,
out of
give us 3 minutes time to go through this.
আমি বলি
Or misleading statement in relation to a material even if it is false, when necessitated by change in circumstances, when the court is satisfied, is with called an undue hardship. It is a court. You have it appearance, what of rights he is this cannot be done. Yes, the appeal is formally admitted. Service come back before the vacation, 21st. Do that. Don't worry.
I have served the caveator. Caveator.
Oh, caveat is there.
Yes.
Who is the caveator?
Caveator, two advocates for different parties, Subhendu Bandopadhyay and Sarvananda Sandal. Senior to Mr. Rai.
Can you secure their presence? Because if they do not come, then you will have to serve.
I find that since the matter 1 year lapse.
Anyhow, serve the parties and 21st. Come. Serve the
Directly
parties.
upon the parties. Right, let it be kept in the department.
That there was no direction, sir.
Caveator.
Serve the court.
Yes, sir. Yes. Yeah.
There may not be a response.
নামটা দেখি
Not a big paper for the appellant, my lord. The plaintiff is the appellant.
Yes.
My lord, the plaintiff
Against an injunction or receiver or what?
refusal of an interim order, my lord. My lord, suit for specific performance
Of
an agreement for sale, my lord. I have paid a certain amount. My lord, kindly sees. The entire amount was.
There is an agreement.
My lord, agreement for sale is at page 20 onwards of the CAN application, my lord. And the receipt of the money by the defendant on the back sheet, my lord.
Page
20 of the CAN application onwards.
Yes.
And the receipt.
Look at it. It was termed as a Shubho Bayana Patro.
Fine.
It becomes an Ashubh. Not a Shubho.
The back page of the stamp paper has also been annexed. They have received part payments up to August 2023. Now, my lord, ad interim was paid for. My lord, that has been turned down on the sole ground. There is no urgency in the matter, my lord. My lord, they have taken part payments till August 2023. Subsequently, they have rejected my prayers of getting the deed registered, necessary deed registered, my lord. I'm only praying for not to alienate the suit property in the meantime, my lord. Not to create any third party interest, that's all, my lord.
Forget about this. The only question which will come in your way, legal point.
My lord.
10 rupees stamp.
My lord, NN Global, my lord. My lord, subject to correction, my lord. NN Global was initially dealing with Section 11 of the Arbitration Act. Subsequently, the Bombay bench, single bench.
But
May
that was taken in a Garware. There was taken by the Chief Justice in one of his judgment. He has not accepted.
The 37.
He has not accepted.
No, my lord, there's a.
Now the question is that whether it can be done, because now the latest judgment of the larger bench, 5-judge bench.
My lord.
Dissent is 3:2.
My lord.
But the majority view is void till impounded.
Impounded.
If it is a void, can a court look into a void document?
Subject to correction, my lord, the court can, while entertaining an application, either Section
If
9.
it is void for all purposes, whether it can be looked into.
My lord, my lord.
Unless impounded.
My lord, I'm subject to correction. It's a fiscal statute, my lord.
That will 2023 volume 9 SCC page 1.
My lord.
5-judge bench decision.
My lord, after that, after the NN Global, another single bench of the Bombay High Court passed an order holding that Section 9 and Order 39, Rule 1 and 2 of the CPC does not come within the purview of the 5 judges bench order, my lord. Then
we may not accept.
My lord may not. My lord may not. But may I, for once.
It is the ratio of the judgment which is very important.
My lord.
It is not the fact which is important.
In my humble submission, fiscal
ratio is fiscal.
It cannot come into the way, my lord.
That was argued.
My lord.
It is really a fiscal statute.
My lord.
It is only for the purpose of augmenting the revenue. It has got nothing to do on the rights of the parties emanates from the agreement discarded by a majority view, saying that Section 33 and 35 of the Stamp Act has to be read in that sense.
My lord.
And upheld the view of SMST.
My lord.
The first view of SMST, and saying that it is void till it is impounded. If a document is branded as void, can the court look into the void document?
Not
voidable.
For protection of the suit.
Voidable.
Protection of the suit property and the protection of the matter in dispute.
I do not know. You just look at that.
Lord, I have gone. My lord,
please go through that.
My lord, the
NN Global last one.
My lord,
2023 volume 9 SCC page 1.
My lord,
my memory goes right.
My lord,
please read that.
My lord. The Bombay High Court single bench was passed after the NN
Bombay
Global.
High Court is a special bench judgment.
No, my lord. No, my lord. That's not the judgment. After the NN Global.
Prior thereto, there is a special bench judgment of
My
the
lord.
Bombay High Court.
My lord.
The Bombay High Court was dealing with two situations.
My lord.
One was the post, I think the Section 11 application.
11.6 was introduced. That's
the post.
My lord.
And one was an interlocutory at Section 9 level.
My lord.
The Bombay High Court answered these two references that so far as Section 9 is not controlled, brindled or circumscribed by a statute or a fiscal statute.
My lord.
The court will definitely grant an injunction. But Section 11, it says no, better.
My lord.
You have to go and impound. That was a Bombay view. Now, based upon that, the subsequent judgment came. Then Garware says otherwise.
No, subsequent
Garware, what is this?
Garware was 2019 9 SCC 209, my lord. Garware was a coastal marine, my lord. Coastal marine.
Garware says otherwise.
My lord.
Then again there was NN Global came.
Initial NN Global
Thereafter. NN Global took a different view of Garware.
My lord.
Then the matter was referred to a larger bench, saying that in NN Global also that this is what we do not agree. Now 5 judges bench, now 3:2 majority.
My lord.
It is still regarded as a 5-judge bench decision.
The review pending subject to correction, my lord, with regard to that judgment.
No. What?
And subsequent to that, Bombay High Court single bench, may I have the audacity, my lord, a single bench judgment which ensures that section 9 and 39(1)(2) will not come in.
Guided if we say,
Lord, may I
please
rely
read
on
the
a
judgment of NN Global 5 judge
Man,
bench.
may I rely on a judgment of this court division bench, my lord? Not, my lord, the Bhaskar.
Prior to
2010, my lord. For my own satisfaction.
you may rely my judgment also. I'm giving you.
My lord.
In 2011-12, you will find my judgment also, which says at the stage of interlocutory application, it will not be guided or brindled by section 33 and 35.
My lord.
That's my view also.
My lord.
I have held, because the language is which used in section 33 and 35 is when the document which is required to be
Tendered in evidence.
get the sufficient stamp is received in evidence. If you look at section 33, say authority to receive the document in evidence, if it is not sufficiently stamped, cannot receive it unless impounded. So receiving of a document in evidence will arise when the witness, when a witness is standing in a witness box and tendering the document so that it can be received in evidence and marked exhibit. So that stage has not come. So I held. But after SMST, I think the Supreme Court, once it has held no, then Article 141 binds us, even if we have taken a different view, but that is binding on us. We can't now take a different view. We are bound.
May I impress the court by the Bombay High Court judgment? Subsequent to that, my lord. Right. It is as different.
I can give you
property has to be
judgments.
protected
I
in the
can give
meantime, my
you-
lord.
I remember at least one or two judgments. One of Justice S.B. Sinha's judgment. The principles, while dealing with an application under Section 9, shall be applied even in case of Order 39, Rule 1 and 2, and vice versa. While considering Section 9, the court will be guided by the principles of Order 39, Rule 1 and 2. So if they are both akin and complementary to each other, then how the Bombay High Court says that it is in relation to 9, not in relation to Order 39, Rule 1? It's the principles which are the guiding factor.
My lord kindly puts the plaintiff in a dictum that the entire motive of the fiscal statute is to with regard to the revenue to
It was argued and discarded in NN Global. That was a
if the plaintiff is directed to secure some amount of money so that
SMST was there. No.
My lord, entire judgment, every judgment was initially subsequently considered in NN Global 5 judges bench, my lord.
And it was argued, fiscal statute, everything was argued.
My lord.
Did not accept. Sorry.
My lord, may I come back?
You have not read the.
And I have read the I have, my lord. May I just come back?
Not meticulously, but with a closed mind.
May I come back one more time, my lord?
More inclined towards your client than the law.
Absolutely. My lord, the law envisages in Order 39 is to protect the property from being wasted away, my lord, from creation of alienation.
But based upon what right?
Based upon a right of a unstamped, unregistered document. If
you claim, then in that event, whether the court can look into the document. That is what there is a very I would say very clear-cut distinction in the language of Section 33 and 35.
It starts from examination and impounding of instruments.
These 33 and 35 both contain more or less same languages, but there is one difference. Look at Section 33.
May I read, my lord?
Please read it.
Every person having by law or consent of parties authority to receive evidence, and every person in charge of a public office except an officer of police before whom an instrument chargeable in his opinion with duty is produced or comes in the performance of his function shall, if it appears to him that such instrument is not duly stamped, impound the same.
Nothing has been said.
No.
35.
Instrument not duly stamped, inadmissible in evidence, etc. No instrument chargeable with duty shall be admitted in evidence for any purpose by any person having by law or consent of the parties authority to receive evidence or shall be acted upon.
This word expression acted upon is an additional word from 33.
My lord.
This acting upon is a very important factor. The court shall not act upon.
My lord.
What is the meaning of this word? Expression acted upon.
Act upon doesn't necessarily mean, my lord, I'll again be redirecting my argument towards the statute being a fiscal one. My lord, my entire endeavor in the suit has been with regard to protection of my protection of the property I have.
You come ready.
My lord,
Come ready.
My lord.
And tell us from SMST onwards.
My lord.
SMST, then Garware, then NN Global initial, and the NN Global final.
My lord. May I have till Thursday, my
In
lord?
between, there is one Opales, if I am not wrong.
Garware was even approved in Vidyadal.
Subhas Opale or something. What is this? In between, there is one more judgment.
There was a post sanction of 11-6 was Duro Felguera, and subsequently Garware was approved in Vidyadalia.
Vidyadholia.
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 Vidyadholia, my lord. It was approved. Garware was approved in Vidyadholia. May I
come ready with all? Let us see. We are not.
May I come back on Thursday, my lord? May I have 2 days?
Tomorrow, day after tomorrow, anytime you want, you can come. When
My
you
lord.
feel you are ready.
Thursday, my lord. May I come?
We are ready. Come.
My lord, I'll be discarding these judgments of this court, my lord. Division bench judgments of this court.
Those were the good judgments prior to SMST. But these are all, they are no longer a good law after SMST has come. I tell you, my own judgment you will find.
This is Bhaskar Bhattacharya's judgment.
True. My
Sitting with
own
Montu.
judgment sitting singly in a revisional jurisdiction, you will find.
My lord, I have seen, my lord. I have. This was a division bench judgment. That's why I only took it, my lord.
You will find that judgment. But later on, after this, no.
And may I for once place the Bombay High Court single bench judgment for once, my lord. Just the ordering portion.
We will go by, then we have to discard this judgment.
Which
by citing some more judgments contrary to this observation.
This is the Bombay High Court single.
That says
My lord.
did not
My lord
notice
can.
the earlier division single bench decisions.
After
court decisions.
No, my lord, this has considered NN Global. After that, this has been passed. Considering SMST, Vidyadhavare and Vidyadholia and SA. My lord,
We'll consider that. You place it. We'll
My lord.
consider. You come with the compilation of all.
my lord, I
the
shall come.
judgments.
I'm grateful.
Tomorrow, day after tomorrow, when Thursday.
Thursday, my lord.
Thursday.
Thursday.
I am for the my if your lordship see once your lordship's order at page 36.
Section 5.
Yes, section 5 and 9 days. According to me, 9 days delay.
Survey.
Now, my lord,
Survey.
Meghajit Mukherjee, my lord, who on an earlier occasion. That's why I'm requesting you, if your lordship see once.
Surveys of section 5.
My lord, if your lordship kindly hear me, page 36, kindly see once, my lord. But I will, Mr. Mukherjee is appearing for the respondent, my lord. My lord, if your lordship permit me, I can serve, my lord.
I do not know Mr. Mukherjee is appearing.
Kindly see once page 36. I had a talk in.
Or Mr. Chatterjee is appearing, but he'll have to serve.
Definitely. Kindly see page 36 once. Your lordship will kindly 6 once.
What 36?
Your lordship's own order, my lord.
Where?
In a suit for partition, my lord, ad interim order initially refused. I came up before your lordship's court. Your lordship was kind enough. Kindly see the order.
No, whatever is there.
Only. Kindly see once, my lord. I am just. If your lordship,
We don't remember anything.
no, that's why I'm showing to your lordship, page 36.
No, that was at the ad interim stage.
Now what happened, as Mr.
Now-
Mukher gives an undertaking that they will not touch the property, your lordship says that no requirement of passing order because in view of undertaking. Now trial court says, as the High Court refused to pass interim order, injunction rejected.
But you'll have to overcome with the
Yes,
condonation
9 days, I will definitely kindly keep it on next Monday, my lord. In the meantime, I will see.
this week.
Service, not this, service. code.
My lord, Mr. Devbrook Bhattacharya appearing in this matter for appellant due to his marriage ceremony, my lord, he is
Oh, so good job.
not able to come to court.
How much time? 15 days after vacation?
After vacation, my lord,
Obviously, welcome. Yes, after vacation. Lepo.
much
The
obliged.
the advocate record of the appellant is indisposed. Let this matter be listed.
No, my lord,
Or not disposed.
no. Kindly let the matter after vacation, my lord.
So we are granting after vacation. Dakho is not available. That will do. Let this matter be listed 1 week after the vacation, Christmas vacation.
Much obliged.
Your lordship, Mr. Rahul Karmakar is for the petitioner, your lordship. He's on his way, your lordship. He's in court number 654, your lordship. I'm paying for a short pass over, your lordship.
How short?
Your lordship, 5 minutes, your lordship. Much obliged, your lordship.
Next.
Lordship, I am for the appellant, Lordship, I am paying for after vacation.
And why we have decided all this order 41 to be taken up before vacation? Why? Because it appears that we will be able to call the entire order 41. Nobody is here. Then it is better we hear the appeal. Unnecessarily, why we will do it, sir. 1 day accommodation, 2 day accommodation, I can understand, sir. But do it.
But next week, Milord?
That you can do, please do that.
Yes, next Monday.
Not this week.
Different.
March तक. You're for?
Appellant. But I am the plaintiff in a suit for eviction, declaration and eviction. Plaintiff.
In a suit for?
Declaration and recovery of possession.
Declaration of your title.
I am the owner. Declaration that the defendant has no right, title, interest over the property and consequently prays for recovery of possession. Suit decreed.
Can a negative declaration be granted?
No. No, my lord.
So
No,
this declaration is bad.
Ultimately, my trial court decreed the suit. Appeal court made out a third case and gone beyond the scope. And this I'm showing to your lordship. But may I just tell your lordship, not telling the facts. Property, my lord, original,
Yes.
but property originally belonged to one Dhananjay and Jyotindra. Dhananjay is 3.5 kata of owner and Jyotindra is 10.5 kata. Now, subsequently, my lord, the plaintiff's mother received the property from the legal heirs of Dhananjay. Plaintiff's mother received the property from legal heirs of Dhananjay.
Purchased.
Purchased. That has, my lord, purchase deed, my lord.
Dhananjay had 3.5 katas.
Dhananjay had 3.5 kata and Jyotindra is 10.5 kata.
10.5. That I understand. Yes. So she purchased means 3.5 katas.
3.5 kata on my lord 12 June 1969.
69.
9.
Okay.
Thereafter, my lord, Jyotindra has 2 sons and my lord, one of the son is Ajit Chatterjee. 2 sons, one is Shonot and Ajit. Now, Ajit Chatterjee, both the sons have equal share. That is, my lord.
So 10.5 is divided into 2.
Yes, 5.25 decimal each. Then, my lord, Shonot and Ajit transfer their 6.5 decimals of land to the mother of the plaintiff.
Jointly.
Jointly.
So 3.3 katas each.
Each. Total comes to 6.6
you said.
Yes. Total.
So 3.3 katas from each. So they were having a 5.25. So 3.3 they have given.
Yes.
So
Rest
virtually they
portion-
kept 2 katas.
Now, subsequently, the legal heirs of the legal heirs of my lord Jyotindra, that is the
Ajit and Sonat.
Ajit's son, one son is
Legal heirs of Ajit.
Ajit.
Yes.
There are three sisters. 3 sisters.
Of
Ajit,
Jyotindra.
no. Ajit has 1 son, 3 daughters.
Okay. 1 son, 3
3
daughters.
daughters.
Yes.
Now, ultimately, there is a partition suit has been filed. That was partition suit has been filed. Now, my lord, subsequently in the partition suit decreed on compromise. Thereafter, decreed on compromise. That was in 20th November 1979. Thereafter, what happened on 12th November 1980, a partition deed has been executed between all the legal heirs and all the co-sharers. Between all the co-sharers,
including your mother,
including my mother. And it has been decided that Chobi Rani, my mother, will be exclusive owner of 1761 and the plot number and the plot
1761.
61.
Yes.
And whatever share my mother had in 1761, that will go to the Shonot and Partho, other legal heirs. They will get. No problem, no dispute.
Sonat and Patru means?
Shonot is my lord, the son, one son of Jyotindra.
Yes, Ajit and Sonat I understand.
Yes. Therefore, my lord, Sonat is my lord, the son, Sonat is son of Jyotindra, one son. And regarding Ajit, Partho is the son of Jyotindra.
Correct.
Now, my lord, no dispute, no problem. Now, my lord, defendants claims to be the owner. According to them, they have purchased the property from my father.
Your father?
My father, who has no rightly interest over the property. Now, ultimately, they could not produce the deed and everything. Now, a trial court ultimately decreed the suit in my favor, holding that they are unauthorized.
Because the property all along stand in the name of your mother.
Your mother. Now, what happened subsequently? Appeal court.
Ostensible owner or the real owner? Mother?
Real owner.
Mother?
Real owner.
Real owner.
Real owner, not ostensible owner, not the from the assets from the father, not that. Now, what happened, my lord? Thereafter, trial court decreed, appeal court dismissed my suit only on the ground that in the partition deed which was been executed, they are the sisters of my lord, the daughter of Ajit has not made party. This is no one's case. Kindly see the appeal court's order. This is the only ground, my lord, for which the appeal allowed. Kindly see the appeal court. The trial court, if your lordship wants, my lord, I can show.
No, it's not necessary.
Appeal court internal page 6. Up to page 5 entirely in my favor discussion. 23 of the contract, internal page.
No, sorry.
But, after memorandum of appeal court's judgment.
I know that
That-
nowadays it is arranged the trial court first, then the appellate court, everything is now in a haphazard manner. Yes, I got it. Internal page.
6, the last page. Up to page 5, it is absolutely in my favor. Internal page 6, kindly see.
Yes.
Moreover, the line starts with moreover.
Subsequent.
Subsequently, according to the plaintiffs, Sonath and Partho executed one partition deed with Chobirani on 12/11/1980, Exhibit 4, whereby Chobirani got entire plot 1761 and Sonath and Partho got entire plot 1760. That is the suit plot. Once again, in this partition deed, Partho's sister were not made party, who had undivided interest in the said property. Section 23 of the Contract Act prescribes that the consideration or object of the contract is lawful and if it cause injury to
Was it
injury.
a case of any of the parties to the proceeding?
Absolutely not, because sisters are nowhere coming.
No, sisters have not come, but any defense was taken in this regard.
Because kindly see the written statement of the defendant against whom I.
They have not said so.
No, written statement are there. Your Lordship can also can get from the written statement which has been discussed by the learned trial judge. Your Lordship will find my trial court judgment, internal page 4.
And who are the defendants? They are claiming through that.
My kindly see, my lord, once my trial court.
The defendants are claiming through your father.
My.
So they have got nothing to
Nothing
do so
with
far
my
as this.
sister.
Your father did not have.
Your Lordship can see also from internal page 4 of the trial court judgment.
The appeal shall be heard on a following substantial question of law. One, whether the Court of Appeal below was justified in making out a new case which is neither pleaded nor any evidence is adduced in this regard. For the purpose of setting aside the judgment and decree of the trial court. Whether the deed of partition executed between the parties thereto in the year 1980 can be treated as can be rendered invalid when none of the parties have challenged the said partition deed, nor the party left out therein have ever assailed the same before the court of law. These are the two grounds.
That I have taken ground number 5.
Ground number?
That I have taken in ground number 5.
So that I have already. No application?
No, but it has come from the department. I also.
So, special messenger costs to be put in within a week. Requisites for effecting service of notice of appeal within a week. Paper book 4 weeks. Within 4 weeks after the reopening of this court. Liberty.
After arrival of law court report that will not required. On the second time will not required. But kindly make it clear, otherwise.
Yeah, he knows it.
Yes.
Your Lordship, the past.
Yes, 5 minutes buffer.
Item number 54, Lords.
5 minutes buffer time was given.
Unfortunately, Lord, but I could not.
Why don't you prepare your juniors at least on facts? Let them start. Let them tell the facts. The law, they will gradually learn. There's no difficulty. They will gradually learn, but will they not say the fact?
No, it's not his fault.
Only for the purpose of Passover and adjournment.
Not his fault. He always gets prepared. Lord,
So
it's,
today
Lord,
we
he
do
was
not
not,
find-
Lord, he did not, Lord, look into this brief. Lord, it's not his fault. Lord, my fault, Lord, I could not, Lord, tell him to get prepared in this matter.
What is the matter?
Lord, the issue is with respect to, Lord, refusal of ad interim injunction in a suit, Lord, for declaration, cancellation of gift deed, and, Lord, recovery of possession. The issue is with respect to, Lord, two properties. 112, Lord, Poddo Noshkor Lane, no? Lord, Poddo Noshkor Lane. The other one is 12/2 Poddo Noshkor Lane. This entire property, Poddo Kumar Rai Chaudhuri second by lane, I'm sorry. Poddo Kumar Rai Chaudhuri second by lane. These two properties were, Lord, owned by one Amulya Chandra Noshkor. Lord, Amulya Chandra Noshkor died leaving behind his.
You are assailing on the ground of misrepresentation and fraud.
Yes.
What is the element?
Lord, the element I have indicated, Lord, Lordship would kindly see paragraph page kindly comes to, Lord, page 30.
What is that deed?
Particulars of fraud I have
Gift
indicated.
deed.
There is, Lord, a gift deed. There is a development agreement. What had happened?
You are only seeking for a declaration, the cancellation of
Cancellation of the deed of gift.
the deed. Now, what is, who has executed? How you are related with?
I have executed. I have executed
They
in
say that
favor
you have executed a deed of gift.
in favor of one of my brother.
Brother,
Yes.
are you married?
Yes, I'm married.
Having children?
Lord,
Or a child?
Lord, widow is the plaintiff number 1, and Lord, one of the daughter is the plaintiff number 2. The defendant number 1 has obtained the deed of gift from the mother and the Lord sister.
So from the plaintiffs.
From the plaintiffs. Now, Lord, what has happened? The issue here is, Lord, 12 and 12/2 both were owned by Amulya Noshkor. Lord, Amulya Noshkor had 5 daughters and 5 sons. All the daughters gifted the entire property to the sons portion.
So everybody has 1/5.
Yes, everybody has 1/5. Now, Lord, this pertains to only, Lord, 1/5 of Sushil, one of the son. Lord, Sushil was, Lord, survived by his widow, 1 daughter, 2 daughters, and 1 son. Lord, Shopna, being one of the daughter, Lord, had died in 2021. Her, Lord, husband and Lord, son are defendant number 12 and 13. They are no way connected to the gift deed. They are already owners of the Lord, property. Now, what had happened is, after Lord, this transfer from the daughter's side to the son's side, the 12 and 12/2 both were, Lord, inherited as 1/5. Now, Lord, we were made to understand that for the purpose of development of both the properties, you gift our share. Why get into partition later? You gift your share in the 12/2. We gift our share in the 12. So the partition is affected. Now that was done, there is no problem. This was made on a representation that both the properties will be developed jointly. Now, after the deed was done, we see that 12 is being promoted, 12/2, the development agreement has been cancelled.
You got share in 12/2.
12/2. But with an understanding that in the 12 also, I am relinquishing the share because we will have a joint promoting for a better FAR and for my better share in the property. That was the entire understanding. Completely family dispute. Lord, what the injunction is about is, Lord, for the time being,
not to alienate.
That's and Lord, the nature and character. Lord, nature and character, Lord, else the promoting is done, Lord, I will be nowhere.
Nothing.
My share.
What will happen?
Lord,
Alienation will not be
Bengali,
there.
in Bengal,
Alienation is not there. So how promoting can be done?
Lord, if the construction is made, Lord, then I will.
It has started.
Lord, it has started. Lord, we had indicated that, Lord.
So you say the development agreement has been cancelled, how it has started?
Lord, cancellation with respect to my part of portion of the
Oh,
land.
correct.
To his portion of the land where he is exercising his rights to my deed of gift, there the construction is there. My portion, the agreement has
So have you seek for a cancellation of all the deeds?
Lord, the deed of gift. We have asked for cancellation of the deed of gift.
So that is in respect of what? 12/2.
12/2. Because that is exactly what I can do.
So there is no construction.
Kindly not seize
12/2 construction is going on.
12/2 construction is going on.
How you say that 12 has been developed?
Is being developed.
12.
Yes,
And
both
12
were family premises.
I understand. You sought an injunction on both.
Yes. Not
Short
kindly
notice, come back on Tuesday.
not some interim protection.
Come, it was
Not once kindly see
in a Rome. If the Rome was not built in a day, it cannot be demolished in a day.
seize page 290 for
Do
my
it,
satisfaction.
Short notice, the appeal is admitted. The appellant is directed to serve the copy of this injunction application upon the respondents by speed post as well as through personal service, and shall file the affidavit service on the returnable date. The application is made returnable. Yes, application is made returnable on next Tuesday. What is the date? 19.
Lord, I am not in a position to bargain, but for the time being a limited interim order, not to
Yes,
alienate.
we do not find that this is a fit case where we should pass an ad interim order at this stage, and therefore the prayer is refused.
Then kindly, my lord, kindly do not give this observation. Lord, later on I will be affected.
Why you invite the court to make a letter observation?
So very well, allows me to come back. I'll come. Grateful. '87.
The suit for partition, my lord, filed by this appellant plaintiff, dismissed on contest by the trial court. Appeal on the trial court held that plaintiff has no yes, plaintiff is not a co-sharer of the suit.
Correct.
Then, my lord, first appeal tendered by this appellant, my lord. The erstwhile advocate appearing before the first appellate court, my lord, was ill. Another advocate was engaged. The learned appeal court gave the last chance to appear, my lord. But simultaneously, another matter also called before the appeal court. Advocate could not reach, and my lord, matter was dismissed for default.
So go and file Here it is dismissed or there it is dismissed.
They are dismissed for default in first appellate court.
So order 41, rule 19 or 20, you can make an application for readmission of an appeal. Why an appeal lies against the order dismissing it for default? Why you are coming before the High Court? How appeal lies? It's a dismissal for default. Where is a copy of the court of civil procedure? Do you have? Okay. You got it?
Yes.
Come to order 41. Look at rule 19.
19.
Look at it, where the appeal is dismissed for default. The appellant may apply to the appellate court for readmission of an appeal.
No liberty may be granted to withdraw this appeal, and I shall take it.
The learned advocate appearing for the appellant submits that due to inadvertence, the instant appeal has been filed before this court. When the remedy can be pursued before the first appellate court. He therefore prays for withdrawal thereof, withdrawal of the instant appeal with liberty to approach the appropriate forum for the self-said relief. We find that the appeal was dismissed for default by the first appellate court. And such order of dismissal for default is assailed in the instant appeal. Considering the provisions contained in order 41 rule 19 of the court, we feel that an opportunity should be given to the appellant to pursue the remedy before the appropriate forum. Accordingly, the appeal is dismissed as withdrawn. However, the dismissal shall not prevent the appellant to pursue the self-said relief before the first appellate court below, in accordance with law. Let the certified copy of the certified copy annexed with the memorandum of appeal be returned to the advocate and record of the appellant upon replacement with photocopy thereof. Which one? 93? 83. No, we have called. What? You are ready? Ready. Other side is here. Somebody may be watching, I do not know. Then at the time of, if we admit, then we will be finding difficulty in passing the interim order. That is what. Then my lord kindly take. Yes, next.
Actually, on behalf of the petitioner in this matter, Learned Senior Mr. Sogoto Miklis appear on behalf of the appellant. He is engaged on courtroom of what I'm praying for not to in this matter.
99 I am for the appellant, my lord.
Come tomorrow, come ready. উল্টো